and also arrive at a decision. Time and time again, the Court helps EAEU members find answers to most pressing questions. Kazakhstan requested advisory opinions on advanced customs declarations of goods, movement of cash across the custom border, division of competences between the EEC and national authorities in competition matters. Belarus requested the Court to clarify the conditions for establishing criteria for vertical agreements and the status of decisions taken by the Commission of the Customs Union. The Kyrgyz Republic sought clarification with respect to the unified rail transport tariff. The Court has reviewed one dispute between Member States, which was initiated by the Russian Federation and involved the fulfillment of obligations in the field of customs cooperation by another EAEU member. Disputes also arise when the Eurasian legislation affects business interests, labor migration, transborder, labor tarification, among others. These questions will be answered. Businesses are mostly active in the domain of customs classification, where goods are improperly classified by customs, the tariff rate will be different, will be higher. Business entities are directly interested in resolving these questions in accordance with the law, in accordance with the EAEU common tariff rates. Certainly, preventing a problem is easier than treating it, so the Court's advisory jurisdiction helps detect and resolve the most difficult questions, where different interpretations may exist. When states conclude treaties, often their provisions are unclear as to the nature of what was agreed. Also, a provision in one act can be different or can conflict a similar provision in the other act. Moreover, there could be a discrepancy between an international norm and a national norm. The Court is in place to ensure uniformity in applying the law, because uniformity is essential for the whole system to function efficiently. The responsibility to take complex legal decisions rests with the judges, appointed by common decision of the Member States. The judges are appointed according to the Chapter 2 of the Statute of the Court. The Court comprises 2 judges from each Member State, 10 judges in total. The power to appoint judges lies with the Supreme Eurasian Economic Council, upon the presentation of candidates by each Member State. After appointment, the judges take oath of office and assume their functions in executing justice. Throughout the 5 years of its operation, the Court of the EAEU has reviewed around 30 cases, delivered more than 25 decisions, and advisory opinions on various topics. Most cases involve customs issues. Another important category is common rules of competition. The Court also reviewed cases on issues such as labor rights of labor migrants, professional athletes, social benefits to international civil servants, tariffs for railway transportation, and application of anti-dumping measures. The first 5 years have marked a crucial period for the Court. During this short time, the Court adopted several judicial acts which contained legal positions on key areas of Eurasian integration. Speaking of a particular case, I would like to point out the request by the National Chamber of Entrepreneurs of Kazakhstan. The question involved the division of competencies between the Eurasian Economic Commission and the national authorities in the domain of competition. The Court decided that there cannot be parallel competence in this area. The practice of the court shows that its competence, as established in its statutory documents, serves to fulfill its functions as a guarantor of justice. The aim of the court is the uniform application of EAEU law by member states' bodies. This goal is achieved in two ways. First, by resolving disputes between member states, and second, by providing advisory opinions upon applications by the Eurasian Economic Commission, by the member states, as well as EAEU international civil servants. All in all, over 40% of applications were requests for advisory opinions. The court has developed legal standpoints on these matters that are being executed in good faith by both the Commission and Member States. The Court's operation is supported by its administration, the Secretariat of the Court and Secretariats of Judges. Appointment of staff members to the administration involves a rigorous competition process. The administration ensures a smooth day-to-day functioning of the Court. Maintaining a fair and efficient dispute resolution, providing clarification of legal norms, ensuring the rule of law and justice. These are the Court's responsibilities. They provide economic security to all 5 member states. The Court of the Eurasian Economic Union is working efficiently. It ensures an objective judicial review of contentious issues between the countries. Therefore, the Court of the Eurasian Economic Union is not born of someone's wish. It's not a whim. It is objectively a necessity and necessary condition for the existence of an economic integration bloc. Simply speaking, no integration can exist or move forward without the court. And if member states really want to create a common, more efficient economy, they should rely on the court acting as a guarantor of the integration process and ensuring the uniform application of common EAEU norms. The Court of the Eurasian Economic Union. Good morning, or good afternoon, dear ladies and gentlemen, attendees to the conference. On behalf of the Court of the Eurasian Economic Union, I would like to welcome you at the 3rd Annual International Conference held by the Court, which in 2020 is held entitled New Challenges in the Integration, the legal dimension. I would like to emphasize that the challenging time of the pandemic did not prevent us from getting together to discuss relevant problems, tendencies of law enforcement, development and application in the EAEU, the matters of justice and integration blocks, coordination of joint intellectual effort, the dialogue between the attendees and participants to the conference, I'm convinced will contribute to resolving complex tasks and objectives that arise through integrational development. I wish to emphasize that this year we have maintained a tradition and got together a wide circle of participants, representatives of EAEU bodies, international institutions and courts, supreme legislature and judicial bodies of member states, civil society organizations, scientists, educational establishments. Over 275 candidates have registered. 52 speakers are to make their presentations. On top of that, 10 address statements will be delivered by top officials. All the judges of the court are involved in this conference. It was shown in the video. You have seen it in the video. They are sitting in this very hall. The topic of our conference is in line with the current year's trends. Medical, biological, and economic tendencies have encompassed pretty much every country out there. The issues, the problems must be responded by international blocs, in particular the Eurasian Economic Union. I believe that the measures taken at the level of the Union to support joint trade, common trade, interaction of member states when conducting anti-epidemic activities, reformatting of institutions to combine online and offline modes of cooperation, have shown the readiness of the Union to work in the new reality and digital reality. Together with that, there is a question: what are the priority directions of development of integration in the future? Recognizing the importance of this problem, we have decided to dedicate the plenary session of the conference to legal aspects of Eurasian Economic Union strategy, development strategy until 2025. This approach to the strategy of the development of the Union will provide for a holistic contemplation of the plan of its development, encompassing matters of achieving the main goals of integration, development of the common market, harmonizing legal regulation in the EAEU, and institutional development of the organization. I hope that the plenary session, according to this topic, will help define the priorities of the development of the organization for various important directions. As for the strategic developments strategic directions for the development of integration until 2025, we need to note that it will expand the powers of the Eurasian Economic Commission, and as a deliverable, it should yield higher efficiency of institutions in the EAEU. However, one important matter, prudential request to the Court of the Eurasian Economic Union from Member States, still needs to be discussed. It's an important tool of dialogue with national courts. It helps them apply to the Court of the EAEU for an interpretation or for for an advisory opinion. As practice, it's prejudicial. Requests, preliminary rulings, is an important tool of harmonious interpretation and application of integration rights. Another important point is access to justice for individuals. The Court of the EU has faced this problem when dealing with a specific case on violation of competition rules. The responsibility of a fine for breaking antitrust legislation was supposed to be extended not just to legal entities, but also to individuals in charge of them. In case legal entities refuse to come to the EAEU court, the officials are essentially deprived of the remedy to defend their legal rights. So there is a question: how do individuals implement their rights on judicial protection in the EU if their rights and interests are affected or possibly even violated by one of the courts in the member states? One of the strategic developments of EAEU development until 2025 mean that EAEU will be a meaningful, important center for the development of contemporary world, built for equal cooperation on the part, cooperation with foreign entities and partners. The principles of international law are supposed to be applied by the court, the applicable, enforceable law, but it's not part of the sources of the law. Defined as the law of the Union. According to the Article 39 of the Charter, of the Statute of the Court is supposed to check the compliance of a specific provision to the legislation of the Eurasian Economic Union. That treaty is the validation of compliance of a legal provision in a member state to the Eurasian Economic Union is important, because otherwise there might be a discrepancy in the legal system. At the same time, when member states
At
the same time, there is a reference to the preamble of the states understanding the rules of the judicial organization, complying with the Charter of the UN and other principles of the court is respecting commonly recognized international law principles, including the territorial integrity of member states. At the same time, international treaties within the economic bloc, third-party involving treaties, Eurasian Therefore, the main aspect of the legislation of justice, as well as the main point philosophy within the Eurasian Economic Union, is whether the decision of the EEC is only checked for compliance with EAEU law as per Chapter 6 in the statute, or to the overarching EAEU law. According to current general freight, the general freight is a system for codifying description of the goods. There is a competence served to the national body as harmonized customs regulation. The court has defined the status of harmonized system in this matter as applicable law. The logic was simple: if the member states have ratified this harmonized system, then each individual member state is supposed to comply with each and every provision of this harmonized system. Therefore, the court has decided that the international treaty, ratified by all the participants of the Eurasian Economic Union members, is enforceable law. If we look at the law enforcement practice of the EAEU court, this court can validate provisions of the European Union law with international treaties. However, should there be conflict, the court will be complying with the European Union's law. Similarly, we need to defend the Eurasian law and order in this principle, following this the same principle as the EU's court. The second part of the plenary session is dedicated to the operation of the Court of the Eurasian Economic Union and member states, the matter of raising their efficiency. Throughout the years of operation, the Court has developed law enforcement practices and provided advisory opinions in various matters, such as customs regulation, protection of free competition, anti-dumping regulations, internal market protection, transportation policies, technical regulation, trades in goods and services, movement of labor force across member states. This scope of matters resolved by the court show its feasibility and show its full-fledged cooperation in resolving the matters by the participants. 22 disputes and 19 cases to clarify, to provide legal opinions have been done by the court. This year, despite the challenging conditions in the pandemic, 6 cases on disputes and 2 advisory opinions have been provided by the court. 5 decisions have been passed, 1 advisory opinion has been issued. Currently, the court is processing 1 dispute and 1 application to provide advisory opinion. As an example, from the cases considered this year, there was a case when the Ministry of Justice of the Russian Federation asked to clarify the EAEU law about the financial leasing granted to economic operators who are non-banks, is that financial services, and whether it's possible to apply it. Prejudicial preliminary ruling in this domain, including taxing them directly, the property tax of the organization. There was an advisory opinion passed showing that leasing services rendered by leasing companies, which are not banks, are regulated by the Protocol on Financial Services. The extended college of the court provided the ruling that there is no importance, there is no the possibility of leasing companies to provide leasing services not being banks is compliant with the EAEU law. The direct taxation is within the scope of jurisdiction of member states and is not within the jurisdiction of the EAEU court. Also, there was a case of applying a fine of for the violation of anti-competition law. The Commission was supposed to look into the assessment of the Belarus RK, Belarus closed joint stock company and Belarus RK. These two economic operators act as competitors, and for this reason the Article 676 of the agreement is not violated, because these are competitors acting in the same commodity market. The conclusion of the Court of the Appeal was deemed premature. The court saw not competition, but unified or harmonious economic operation of these entities. Only the cited examples are enough. These cited examples alone are enough to demonstrate that the role of the court in enhancing the legislation of the Eurasian Economic Union is very high, including breaking down barriers and improving the situation in the commodity markets of the EAEU. Given the complexity and multilateral nature of disputes with which integration blocks judicial bodies have to deal with, the program of our conference involves several specialized sections: international law, challenges and tendencies, and procedural aspects of activity of international courts and electronic legal proceedings. Particularly, the Section 3 of Chapter 5 of legal proceedings will be dealt with. The interpretation of the norm of Item 72, Article 72 of this statute helps arrive at two possible options of its interpretation. The interpreted norm within the court, the interpreted norm means that the court, as part of the grand jury, can consider only those procedural issues that the grand jury faced, or all procedural issues that have arisen as a result of the activities of the court, both in the composition of the juries and appeals chamber. At the same time, it's not clear whether a judicial decision or a legal opinion will be provided as an outcome of this consideration. Also, we need to look at who is in power, whether it's any court or particular entities. What would be the legal force of this decision if it is adopted at the session of the extended jury? What will be its mandatory effects? Another very important debatable issue was the matter of operation of the court when forming the college and chamber of appeal. The system when the appeals chamber and the juries become take precedence, take in turns, is disputable. If one one set of judges acts as the juries, and then the appeals chamber is then followed, since the instance of appeals is passing the finite decision, then this can be the case of competition between the two chambers. The approach where the jury and the appeals chamber are permanent would be more prudent. 5 judges will act as juries, and 5 will act as the appeals chamber. However, this can jeopardize the section Article 20 of the statute. All the judges are supposed to share the similar workload. In this case, not cases will be appealed, and the appeals chamber will be involved to a lesser extent. Nonetheless, the efficiency of this operation was proven when the appeals chamber confirmed or overturned the decision of the jury's chamber. The appeals chamber will always support the instances, the decision of the first instance. The keynote topic of this year, as declared, will be the matter of new challenges of integration of the Eurasian Economic Union. Around them, of paramount importance are human rights protection and economic security. Economic security, as a comprehensive category, involves provision of fairly high and sustainable economic growth, efficient satisfaction of economic needs. Protection of the freedom of competition, developed antitrust regulation are essential components of economic development of the EAEU. Our third section is dedicated to this topic. Talking about counteracting new threats, I believe that there is no such thing as one-fits-all approach here. At the same time, such formulae is clear following the objectives and principles of the integration, planning, human rights are supposed to be top priority. This will contribute further integration and clarifying the main issues of the further development of integration in the EU, running all the way up to 2025. We are publishing the compilation of articles and reports according to the outcomes of the conference. We will be pleased if the attendees and participants provide their works this year as well. I wish all the participants of the third annual conference of the Court of the EU fruitful work, interesting discussions, and good luck in searching for the questions of our time. Now I would like to give the floor video address Mikhail Мясникович, Chairman of the Board of the Eurasian Economic Commission. The law of the Eurasian Economic Union is a living organism. It is supposed to be developing. Therefore, in current conditions, we're supposed to look for options to find those or other decisions. Constraining factors include particular restrictions such as lack of legal regulation in economic operations. Although this development is foreseen by the EAEU legal framework development. Currently, the registry shows 35 constraints. 35 constraints. I would like to emphasize the fact that these constraints rest with the directions of economic activity, which were not reflected in the legal domain of the Eurasian Economic Union. Regardless of the fact that a part of the previously identified restrictions was eliminated, there are new restraints, new constraints, new hurdles arising as EAEU goes forward. In this case, we are seeing lack of positive dynamics, which is something that concerns us. I mean, the old obstacles are removed and the new ones take their place. The College of the Eurasian Economic Union, supported by the Member States, have offered several novelties to remedy this. The project of strategic development of EAEU until 2025, which was largely adopted, which was comprehensively adopted on May the 19th, 2020, by the Member States heads, is supposed to deal with the gaps in the legal regulation in the Eurasian Economic Union. Accordingly, this document sets forward a number of comprehensive tasks to complete the formation of shared market, of common markets for goods and labor force, and eliminating obstacles when operating within EAEU. This direction will help lift barriers, will help harmonize the regulation of key services sector, development of common payment settlement space, expansion of the use of national currencies in bilateral settlements, and other domains of activity. Of high importance to this document, the planning of strategic development, is improvement of customs and customs regulation, digital space creation. We believe that full-fledged implementation of the development until 2025, of the EAEU until 2025, involving international lawyers, but not just them, will help remove barriers in the internal EAEU market, will raise this work to a brand new standard. Special hopes is placed by us in improving economic, competitive and investment attractiveness of the EAEU, its scientific potential. Without it, new industrial politics, new industrial policies will not be made possible. There's a lot of talk around that topic, but not too many pieces of legislation passed governing international industrial development. Mutual augmentation of the development and creation of trans-Eurasian companies, this is what we see as the future of the industry of our economic bloc. Secondly, apart from the issues such as the lack of economic regulation within the framework of the EAEU, there are also issues arising because of many other obstacles. Barriers to the internal trade because of non-compliance of national legislations to the regulatory framework of the EAEU. Regardless of the fact that 51 obstacles have been removed over the past 3 years, nonetheless, the registry of such obstacles lists 62 new obstacles, which goes to say that the Member States are not compliant with the obligations assumed by themselves within the framework of the bloc, and they create ever new hampers and barriers in the common trade. Same with constraints and restrictions. Old ones are removed and new ones take their place. There is a horde of reasons to this for such obstacles. Particularly, Member States adopt national legislation which is not compliant with the EAEU legal framework. Sometimes these provisions, or sometimes national. One member state adopts provisions conflicting another member state's legal framework. In this case, we need to strengthen the organizational role of the bloc's bodies and institutions to remove barriers and develop the shared market. A huge role in this work goes to the court of the EU, which is supposed to ensure harmonious enforcement of the EAEU legislation by all member states. We work closely with the management of the court. I wish to thank the colleagues from the Eurasian Economic Union Court for the understanding of the questions and the matters and the support of the directions implemented within the Eurasian Economic Union. Within the EEC. I wish to particularly emphasize that the conclusions in the decisions and legal opinions by the court are actively taken into consideration by the EEC to efficiently remove trades and barriers to common trade. In this case, we feel very strong support from the court. We hope and believe that the court will not just be limited to very much needed work on clarification and harmonious interpretation of various elements of legal framework and objective resolution of disputes. The court will also take immediate role in implementing and improving the legal framework of the EEC, lending its helping hand to its ally, standing up for the interests of the Eurasian Economic Union. Esteemed colleagues, attendees, the current situation is high volatility in international markets, including the energy market. The complications we have faced because of the coronavirus pandemic, growing recession trends, all this means that we must join our effort, and we should not just be supporting our integration, we should be developing it using new modes of cooperation. Even the activities of our today's conference, of our 3-day conference, is a new phenomenon. We're talking and we're communicating with each other using digital platforms, online conference facilities. I believe that this format of cooperation will be made use of in the future as well. When we have fought and combated this pandemic, we will go back to business as usual. I am convinced, dear colleagues, that the conference to which you have invited top experts, members of the academia, scientists, thank you very much again for inviting me to take part. We, with the legal department of the EEC, have been preparing for this conference, definitely. And we plan, we hope that the conference will become a decent discussions platform. It will facilitate experience exchange between international governments, authorities, business circles, which is very important. Business communities must never be ignored. We need to strive to resolve their applications, and we need to take care of the science community. All these efforts will be channeled towards the development of the legal framework of the Eurasian Economic Union. I wish all the participants and attendees to the conference fruitful work. Once again, thank you very much for your kind attention. I plan, and I do hope that the ideas and concepts voiced in my brief introductory statement will be somehow, to a certain extent, guiding the discussion, will be kind of a mild criticism to resolve the relevant issues that our integration bloc is facing. Thank you very much. Good luck.
Владимировича за столь высокую оценку деятельности суда. Такие предложения, которые были высказаны.
I would like to thank Mikhail Мясникович for the introductory statements. I would like to give the floor to Mr. Lebedev, chairperson of the Russian Supreme Court. On November the 26th, the plenum of the Russian Federation Court adopted a decision in which it clarified that when implementing and interpreting, starting over again, Dear Jolombet, dear participants of the conference, I would like to welcome you on behalf of the Supreme Court of the Russian Federation. The Eurasian Economic Union is a dynamically developing international bloc which is based on the principles of equality and mutual respect. The integration in the legal domain is contributing to the strengthening of the economic space, expansion of cooperation across the bloc's member countries in customs regulation, protection of competition, antitrust regulation. An important prerequisite for integration is harmonious interpretation and enforcement of the Treaty on the Eurasian Economic Union. The decisions of various bodies within the EAEU and other international pieces of international legislation supported by the EAEU Court. Decisions, advisory opinions by the Court are contributing to the harmonization of legal approaches, of the protection of rights and legal interests of economic operators within the bloc, the development of law enforcement practice in member states of the Union. The Supreme Court of the Russian Federation places high importance on the matter of interpretation of rulings by the Court of the EAEU. In November 2020, the plenum of the Supreme Court of the Russian Federation have deliberated on the customs code of the EAEU, where it explained that when interpreting and applying the EAEU rules in the domain of customs regulation, the courts are supposed to proceed from the acts and decisions of the Court of the Eurasian Economic Union. The Supreme Court of the Russian Federation applies the decisions by the EAEU Court when handling economic disputes. On top of that, the Supreme Court of the Russian Federation also files responses, also submits legal advice, legal opinions on the law enforcement. And the judges of the Supreme Court take part in the conferences held by the Court of the EAEU. I am convinced that the interaction between the Supreme Court of the Russian Federation and the EAEU Court will be strengthened in the future as well. Dear participants to the conference, definitely your activities will be constructive, will be fruitful, and it will make a positive contribution towards the development of relations between member states of the EAEU. I wish you successful work.
I would like to express gratitude to you, Mr. Vyacheslav Mikhailovich, for the greetings, for the issues that you have been touching and then related to interaction of the high judicial bodies of the Eurasian Economic Union and the Court. The floor to welcome is offered to the chairperson of the Constitutional Court, Mr. Mami Abdurazakovich. Esteemed participants of the conference, ladies and gentlemen, I would like to use this opportunity on behalf of the Constitutional Council of the Republic of Kazakhstan to greet you personally, express gratitude to organizers of the forum for the opportunity to talk to you at the opening of such important event. This time we are forced to participate in the online format. I'm sure that in the future, in the nearest future, we might be able to see each other in the traditional format. The topic of the current conference is of great interest. Kazakhstan has always been active supporter of the Eurasian economic integration. As you know, this idea for the first time has been voiced by the first president of the Republic of Kazakhstan, Mr. Nursultan Nazarbayev, in 1994 in the city of Moscow. The treaty itself, the agreement itself about the integration of the Eurasian Economic Union was signed in Kazakhstan in 2014. During these years, integration processes at Eurasia space has been developing rapidly. There is close interaction between the countries within the framework of the economic union. As the union deepens and grows, they develop legal institutes. All these measures are aimed at improvement of important competitiveness of the national economies and improvement of living standards of the population of the member states. I would like to note an important element of activities of the Court of Economic Union, Eurasian Economic Union, that is placing a lot of efforts to ensure law and governance in this sphere, further development of legal mechanisms in solving disputes. The current epidemic made it important to think very carefully the international and national legal frameworks from the point of view of its compliance with the new challenges and requirements. Quarantine, closure of the borders, introduction of the counteraction to the global threat impact the integration processes. In this respect, it is important to ensure taking into account interests of all the parties and compliance with the agreements reached. I'm sure that this forum will enable us to discuss important issues and develop international important suggestions to modernize, promote legal basis between the integration between the. In conclusion, I would like to express the gratitude to organizers of the conference. In the course of a number of years, between the Constitutional Council of the Republic of Kazakhstan and the Court of the Eurasian Economic Union, there has been fruitful cooperation, and we are grateful to the representatives of the European Court, in the participation of the fourth Congress of the International Conference dedicated to 25th anniversary of the Constitution of the Republic of Kazakhstan. I would like to wish you all constructive dialogue, active participation, and fruitful activities. I would like to express gratitude to Kairat Abdurazakovich for high evaluation of our activity jointly with the Constitutional Council of the Republic of Kazakhstan, and give the floor to welcoming address to the chairperson of the Constitutional Court of Armenia, Mr. Arman Dalanyan. Respected participants of the conference, respected colleagues, ladies and gentlemen, on behalf of the Constitutional Court of the Republic of Armenia, I would like to welcome you, all participants of the conference. First of all, the chairperson and the judges of the Economic Court, and would like to express gratitude to the Secretary of the Court for the organizing of this important conference. I'm sure that during this multifaceted conference we are expected to have deep and interesting discussion. Respected participants of the conference, today's topic of the conference is important to all member states of the Eurasian Economic Union, and not only for them. In 2020, we have faced with the fundamentally new challenges which give threat not only to our healthcare systems but in general to society. So basically they are creating unprecedented issues, problems for national judicial and legal systems. At the same time, due to coronavirus, the global turndown reflects within the situation in member states of the European Economic Union. The situation is more complicated, that it's not known how long the pandemic would last and what would be development would be in the nearest future. In this kind of difficult situation, the national judiciary and supranational courts will have to play a unique role to ensure respect of the principle of the rule of law, protection of rights and fundamental freedoms of citizens, and administration of justice. Respected colleagues, it is alienable truth that the law must be equal, accessible and affordable and applicable to all. At the same time, it is of the same importance to improve the regulatory framework within the EAEU region that would ensure the efficient implementation of the rights and respect to responsibilities of the citizens, contributing to development of economies of the countries. In this respect, and particularly due to new challenges and changes in various spheres of public life, it is necessary to continuously review both national and supranational legislation and that is undoubtedly would serve ensuring effective protection of human rights to the fullest possible extent in their activities, ensuring equal rights for the economic competition and effective administration of justice. The rule of law, in turn, serves an important basis for the balance and cooperation between the different branches of power, social, economic behavior of the individuals in the legal state. At the same time, ensuring constitutional guarantees is of primary responsibility of each country. In this context, the strategy for development of Eurasian economic integration until 2025 is of special importance. The processes and mechanisms reflected therein would ensure increase of the efficiency of the EU institutions, including the Court of the Economic Eurasian Union, as well as the attractiveness of the Union, improvement of legal mechanisms of its competitiveness, effective, efficient protection of the rights of entrepreneurs, and increase of scientific and industrial potential. While concluding, I would like to ensure that the Constitutional Court of Armenia will develop its relations, the Economic Court of Eurasian Economic Union. I'm sure that readiness to cooperate testifies the Eurasian integration is also deepened in the judicial and legal sphere, and it's of great potential for further development. I would like to wish you success in the course of activities of the conference, and thank you very much for your attention. Thank you very much, respected Armen, for your welcoming address, and I would like to express our readiness on the part of the Economic Court to continue cooperation with the Constitutional Court of the Republic of Armenia. The floor, the welcoming address, is offered to Valery Mitskevich, Deputy Chairperson of the House of Representatives of the National Assembly of the Republic of Belarus. Very good afternoon, respected colleagues. It is an honor to welcome participants of the third annual International Conference of the Court of the Eurasian Economic Union on behalf of the MPs of the House of Representatives and on behalf of the Belarusian lawyers. The Court of the Eurasian Economic Union plays an important role in the respect to rules of the law of member states, ensuring the effective functioning of this unique integration mechanism, association. Therefore, the topic of this conference is consonant: new challenges in the integration of the EU, the legal dimension of it. Despite of its youth, this judicial body has proven that it's mature and competent. During the years, it has become authoritative and professionally fulfilled its main purpose to ensure uniformity in application of the law by the treaty and member states of the provisions of the Treaty of the Eurasian Economic Union, international treaties and decisions. Certainly, the activities of this year have set new objectives and tasks to Eurasian Economic Union in general and for the member states in particular. Certainly, outbreaks of the coronavirus has made its adjustment into our life, the new reality, and we had to learn to work in it. It's not only regional, but also international organizations have changed the format and direction of their activities. In the first place, all over the world, there are issues of healthcare arising. In the second wave of COVID-19, and according to WHO estimates, reaching its critical stage, the fight against coronavirus has become one of the most important items of the domestic and international agenda, as the healthcare requires global and decisive activities. In May 2020, a meeting of the Supreme was held and chaired by the President of Belarus. Heads of the state approved the protocol on amending of the Treaty of the Eurasian Economic Union, discussed the activities of the year, and approved the main guidelines for the macroeconomic policies of the countries for the period of 2020-21. It should be noted that the decision taken at the highest level show that the EU is ready to successfully confront new challenges and threats. It's going to do everything necessary to contain the negative impact and minimize economic consequences of the external shocks related to coronavirus problem. I'm sure that only coordination of joint events, including the legal community, would become the basis to solve issues and problems of regional and global nature. The court, as the permanent judicial body of the Union, has an important role to play in development and strengthening of integration processes, especially at the current stage when the global world needs a balanced, fair settlement of conflicts. The proof of its activities is the judicial practice on broad such as customs regulations, protection of competition, anti-dumping regulation, measures of protection of internal market, transport policy, technical regulation, trade of services, movement of labor force, labor and social rights within the framework of the Union. All decisions of the court are aimed at improvement of the international legislation and strengthening of the Union as an international organization. Holding the conference this year as offline has proven the readiness of all of us, judicial bodies, to function in the reality of the digital world. The program of this conference is built in a way that it touches the major issues of integration within the Union. I'd like to underline that the special importance is paid to strategy of development of the Union until 2025. The section court of the EU and courts of the member states would enable exchange of opinions, developing of real proposals, and on interaction of the judicial bodies and application of the practices. It is of no doubt important second aspects of international law, professional aspects of activities of the Union's court, protection of competitiveness and anti-monopoly regulation. I'm sure that the conference will allow discussion of key aspects of integration within the Union, its trends, as well as challenges to international justice at current stage. Involving a wide range of representatives of the judicial bodies of the Union and member states, as well as international courts, Eurasian Economic Commission, leading scientists, practicing lawyers will not only contribute to the fruitful activities of the conference, but would also ensure an opportunity in developing practical recommendations and suggestions. In conclusion, I would like to wish all of us successful activities as well as constructive dialogue. Thank you for your attention. I would like to express gratitude to Mr. Mickiewicz for your permanent participation in similar activities. As well, we are glad to see among the representatives, we would like to, happy to see Mr. Andrei Savinych, permanent chairperson of the Commission on International Affairs, members of the House of Representatives of the Parliament of Belarus. Wish you all the best, dear colleagues. Thank you very much indeed. The next would take the floor would be Deputy Chairperson of the Supreme Court of the Kyrgyz Republic, Ms. Tokbaeva Aynash Abdimanovna. Respected Mr. Baishev, dear colleagues, ladies and gentlemen, on behalf of the Supreme Court of the Kyrgyz Republic, and on my own behalf, I would like to welcome you, all participants and guests of the International Conference of the Court of the Eurasian Economic Union that is conducted online regime. Each year, the number of guests and participants of the conference is going up. And today's new format would enable discussing issues involving broad number of participants. The conference of the Court of the Eurasian Economic Union, for the third time, has put together representatives of the authorities, scientific, legal, in order to discuss important issues of development of Eurasian Economic Union, as well as international justice. That would assist in developing efficient mechanism of strengthening of integration of economic development within the framework of Eurasian Economic Union. Success of the Union, to a great extent, depends on the successful activities of the Court of the Eurasian Economic Union. Absence of the unique approach to interpreting of legal acts would seriously or might seriously complicate the processes of consolidation. The law of the Union is the fundamental principle of the link between the states, puts together the member states and plays the key role in further development of Eurasian economic and legal integration, especially in the legal sphere. The Court of the Union, as major interpreter and potentially the creator of the law of the Union, has to provide unique comprehension and interpretation of the law by the member states and economic agents. The Court of the Union developed certain judicial practice that enables economic agents, the bodies of the Union, the member states, has the law and image that are taking shape in the Union. Publication at the site of the Union, evidence about openness and transparency of the court. It is important to note that the EU court ensures and improves attractiveness of states from the point of view of investments. International Court itself creates favorable conditions for investors that justifies reasonable expectations of the business involved in economic operations, as well as improve and then deepen and strengthen the investment activity in different regions. I'm sure that the aspects and issues on the law of the agenda would deeply impact development of legal relations and strengthening mutually beneficial cooperation in the judicial sphere, would bring new content in our interaction. In conclusion, I would like to express deep respect to activity of the Court of the Eurasian Economic Union. I would like to express my gratitude to the chairperson of the Court for the invitation and the opportunity to take the floor. I would like to wish every participant of the conference fruitful activity, interesting discussions, and new ideas. Thank you for your attention. Thank you very much indeed, and we hope to continue fruitful cooperation and see you and hear you at this kind of conferences with your suggestions and proposals. Next, the floor is offered to Natalia Karpovich, Deputy Chairperson of the Constitutional Court of the Republic of Belarus.
Good afternoon, esteemed Mr. Baishev, esteemed ladies and gentlemen, colleagues. On behalf of the Constitutional Court of the Republic of Belarus, I wish to welcome the attendees of the International Conference, New Challenges for EAEU Integration, the Legal Dimensions. There is strengthening of development, strengthening of cooperation of states in trade and other domains. International contexts are on the rise. Migration of the population, international economic activity of the population have picked up. These are the positive trends for the Eurasian integration development. It gives us food for thought as to the prospects of its modernization and changes for the better. At the same time, the current conditions of the economic Eurasian Union development also include some adverse trends. First and foremost, this is the impact of political factors on the economic processes, which is strengthened in the global scale. Differences of economic operators in various countries shine through because of different resource potential, resource capabilities, different socio-economic environments they operate in. However, these tendencies, they contribute to multifaceted and non-linear nature of international cooperation. They cannot destroy, they cannot disrupt its gradual development, given that the interests of all stakeholders of this cooperation are respected. Given the integration processes in the Eurasian space, the treaties within the EAEU provide the governance, provide the legal foundation. Such development is in line with the demands of time. It must have a legal dimension. It must be based, the development must be based on the legal instruments in the Treaty on the Eurasian Economic Union, such as the harmonization of the legislations of our government, of our countries, the compliance with the decisions of the EAEU bodies, and so on. Thus, the legal dimension of the Eurasian integration development demands profound analysis of the law, legal framework, its content, which is overarching with respect to all the integration development related matters, and response to new challenges. I would also like to point out that settlement, peaceful settlement of disputes to ensure well-being of the citizens is served by the international law. Its guardian and its advocate, its defender, are the bodies of international justice. The activity and operation of the EAEU Court, which is supposed to provide harmonious foundation of the integration bloc development and provide long-term prospects for the Eurasian Union's operation, are the necessary prerequisites for the integration to succeed and for the goals of the bloc to be met. The Court of the EAEU has been up and running for 5 years in its capacity. Early this year, President of Belarus, Alexander Lukashenko, made an address to member states' heads, where he appointed, where he highlighted the necessity to raise the importance of the Court of the EAEU in the light of new integration development trends. So we need to summarize the accumulated expertise, we need to implement the potential of the Court of the EAEU, proceeding from the objectives at hand. Dear attendees, the conference's agenda makes it possible to discuss various points that I have highlighted earlier. We need to make sure that the Eurasian Economic Union operates on an equal, non-discriminatory footing. The courts of member states and other international courts must respect the decision passed by the EAEU court. In this respect, I wish to point out that the Constitutional Court of Belarus, exercising oversight of the compliance of the country's legislation, also helps harmonize and helps implement the EAEU legislation into the national legislation of Belarus. Because of the role of the court and because of the importance of international relations, the rule of law is of paramount importance. In international blocks, it is improved, it is advocated and ensured by respecting the balance between the national interests and the common interests, the bloc's interests. Respecting the standards in the human rights domain. I am convinced that the saturated agenda and the authoritative composition of the attendees to the conference will help us comprehensively discuss various aspects of EAEU Court's operation, the protection of the judicial interests of legal entities and individuals. I wish fruitful work to all the participants of the conference. May you have constructive discussions and all the best. Thank you very much for your attention. Thank you, Natalia. Being in the country of the headquarters, I would like to give the floor to Yuri Kobets for an introductory statement. He is the Deputy Chairperson of the Supreme Court of the Republic of Belarus. Esteemed Mr. Chairman, dear colleagues, on behalf of the Supreme Court of the Republic of Belarus and for me personally, I wish to welcome the attendees of today's high-level international conference with high representation. The third forum of the Court of the EAEU is continuing the tradition of long-awaited events looked forward by the judicial community of our country. The peculiar feature of the conference this year is its online format, which contributed to efficient remote cooperation in this tough period, this tough epidemiological period. The speakers and attendees have received access to a platform to discuss various international matters and aspects which are of high relevance and of high professional interest. The Supreme Court of the Republic of Belarus much appreciates the opportunity to participate in this forum, holding which contributes to developing harmonized approaches and harmonization and synchronization of legal frameworks in the shared EAEU space. The legal systems of member states are built in such a way that professional cooperation and interaction between the courts of our countries is a paramount element of overarching stability, justice, law and order, including the economic domain. I wish to point out that we have had very good friendly relations, a high level of professional interaction, and I'm convinced we will contribute to strengthen international legal cooperation. So in this case, in my capacity, I wish to emphasize that the harmonious practices when handling cases by courts of member states also contributes the formation of shared EAEU legal space. For Belarus, same as for other countries of the world, it is particularly important to ensure granting access to justice in the light of coronavirus pandemic and preventing its adverse social consequences. In this case, we need to ensure, in this challenging setting, we need to ensure the rights of the people to judicial protection and protection of health. On the wave of the pandemic, of high importance are digital technology. Digital technologies serving the proper law enforcement and legal proceedings in this atmosphere. Digitization, going digital by the courts of the regional and provincial levels have caused or have ensured preventive measures taken by the courts in this tough period. ICT and online capabilities help us overcome various barriers for international communication and social development. The online format of today's conference is yet another testimony to the fact. Particular importance of this event is because it is attended by top experts and scientists, representatives of Supreme Courts of the member states. I'm convinced that the contributions by the attendees today will improve the legal foundation of the bloc's development and the development of international relations in the domain of international cooperation. The relevance of the agenda will help boost new initiatives, new projects and ideas, coming up with efficient resolution of aspects of problems and issues faced by the EAEU. I'm convinced that this conference will be remembered as a milestone, important event, which is very much in line with the spirit and the challenges of our current time. I wish the attendees and participants fruitful work, interesting discussions, new interesting suggestions, and a successful experience with this international forum. Thank you, dear hosts.
Thank you, Yuri. We are grateful to you and the Supreme Court of the Republic of Belarus to the permanent attention to activity of our court and effective interaction between our judicial bodies and court bodies. Welcoming address is offered to Mr. Mikhail Borisovich, Head of the Department and Cooperation Policy within the frame of Human Rights of the Council of Europe. Respected judges, respected participants of the states of Eurasian Economic Union, ladies and gentlemen, dear colleagues, I am pleased to welcome you on behalf of the Council of Europe at the traditional annual conference organized by the Court of the Eurasian Economic Union. The Council of Europe, including the European Court of Human Rights, traditionally participates in your conferences. This 2020 would not be an exception. Last year, I do remember that in Minsk, during the conference, you have been summarizing results of the 5-year activities of the Court of the Eurasian Economic Union. And today, your program is prepared in a way so that you have to answer a number of challenges of the future at the new stage. Here we have to note that 2020 has become one of the most complicated, complex year in the humankind history. This from the epidemiological crisis, similar to which the humankind has never been faced with for more than 100 years, and the year during which we have faced the escalation of the armed conflicts. We have seen the political turmoil, and certainly this is poses very serious threats impacting activities of all international organizations, including the Eurasian Economic Union. But we have to note as well that during 2020 we had seen good events, nice events, pleasant events. Earlier in November we have marked 70th anniversary of the European Convention on Human Rights, one of the most important and the best international treaties in the history of humankind. To say nothing about history of Europe, this treaty, this agreement, we have to consider as a key, not only in overcoming the crisis, but as well in solving numerous objectives and tasks that we have been faced with as international community. In this respect, I'd like to note that the Council of Europe, multifaceted, multidimensional cooperation and protection of fundamental rights, today lies as makes foundation for any action, and to say nothing about the actions that we need in order to overcome the challenges that again we are faced with today. In turn, and it impacts the objectives of the Eurasian Economic Union, like strengthening of economic, mutual and fair cooperation with other countries, cooperation with the international integration, creation conditions for stable development of economies of the member states in order to improve living standards of population. Citing preamble and Article 4 of the Treaty on the Eurasian Economic Union. As well, in this respect, we need to note, I'm pleased to note, that both Council of Europe and Eurasian Economic Union mutually are interested of each other's activities, cooperate, and I know that you are carefully tracing what is taking place, taking shape in the Council of Europe. You're following the practice and its development of European law and human rights, and you make use of this practice in your activity. In turn, the Council of Europe pays attention to activities of the Eurasian Economic Union, and from the time of the last conference we have been faced with the interesting report, managing committee of steering committee of the Human Rights Committee in Europe, that is dedicated to this place that the European Convention, and then part of its report, it's dedicated to activities of the Eurasian Economic Union. So once again, it underlines the interaction and mutual connection between our activities. And it's necessary to note, I have to note in this respect, that consultative opinion of the Court of the Eurasian Economic Union that has paid a lot of attention to the previous year's conference, that is consultative opinion dated 2018, that has fixed requirements of at least minimum standards in respecting the Union, the compliance with the rights and freedoms, at least that guarantees that internal law, domestic law of the member states of the Union. And certainly this kind of decision, this kind of court decision evidences about deep understanding and proper understanding that development of economic integration is impossible without common understanding of respect to rights, not only economic entities, but the rights of citizens that would are becoming the more active in the integration processes. I'm sure that development of practice of the Eurasian Economic Union would follow this way, as it is evidenced as the practice of other integration associations, unions, organizations, evidence, and then development of the similar practice in the European Union. So consultative opinion of the court dated 2018 sounds in the same way that the Communities Court at the appropriate stage of its development has been adopting as integration association. And I'm sure that these two elements that I've been paying attention to earlier, multifaceted or multidimensional cooperation and protection of rights and freedoms of citizens, should make foundation of the successful strategy of development of the Eurasian Economic Union. And these two vectors would enable overcoming any crisis. At this positive note, I would like to wish all participants of the conference interesting and productive discussion. Thank you very much indeed. And with hope, I'm looking into the future for the personal meetings in the nearest future, I hope, as we would overcome the crisis that we find ourselves in. Thank you very much indeed, and I wish you a successful conference. I would like to express gratitude to Mr. Lobov for such appropriate evaluation of activities of our court and interaction of issues with Council of Europe. We hope to continue cooperation with this institution in the future. The floor is given to Firbjorn Flogaitis, head of the European Public Law Organization.
Dear participants, I'm very honored to have been invited to say a few words on the occasion of the Court of the Eurasian Economic Union to study and promote the law and governance of integration institutions around the world, and more specifically, the integration mechanisms of the Eurasian Economic Union. The court plays a great role into the integration process of the Eurasian Economic Union, especially because it creates, through the lines of its own jurisprudence, the law and the jurisprudence of this new international initiative. The civil servants serving international organizations need the protection of a legal system, the legal system which is drafted by the international organization for them, but also the legal system which is guaranteed by a court at the supreme levels of the grievance system of that organization. I have a personal knowledge of the work which is being done by the Court of the Eurasian Economic Union, because the European Public Law Organization, the EPLO, has this initiative to gather together every year around 10 the major international administrative courts of the world in discussions of promotion and deepening of the knowledge of international administrative law. And I want to congratulate the Court of the Eurasian Economic Union for its efforts and its results in law making in the Union. The EPLO, all the same, knows very well the work which is done by the Court of the Eurasian Economic Union, because we have a very important for us memorandum of understanding signed with the Commission of the Eurasian Economic Union. We are very honored by that, and this demonstrates the genuine interest that we have in the advancement of the relations of the EPLO with the Eurasian Economic Union. I wish you all the best for the works which will be done in within this important event, And I thank once again the court for giving me the floor and inviting me to participate in a moment of joy and promotion of the work done. All the best, spiritual leaders.
Спасибо большое, господин Влогайтис.
Thank you very much indeed, Mr. Flagaitis. Would like to express our gratitude to you in turn and would like to wish you success in your activity. We have the welcoming addresses that have been filed to the court. As well, there is a written number of welcoming addresses in writing that we received. I'd like to wish one of, at least part of it, that was sent by the state of the Belarus Union, Mr. Rapota. There's a welcoming address received by the court, where we underline that strengthening of economic relations between the member states of the Eurasian Economic Union, so this close need to improve cooperation in the interpretation of the international agreements and solving international disputes. I'm sure that the discussion at this conference would be fruitful and the recommendations developed would find its application and practice. Would like to wish you success in your professional activity, high results in achieving the objectives and goals. Thank you very much indeed, Mr. Rapota, for the attention that you have shown to our conference. Now I'd like to give the floor in the course of plenary activities for the number of people that have expressed the idea. The floor is given to the rector of the Russian State University of Justice, Mr. Valentin Yershov.
Unfortunately, no sound is streamed.
В режиме онлайн бывают накладки.
Sometimes this happens in the online mode. I believe that the connection to Mr. Yershov is being established as we speak.
Пока связь налаживается, давайте попробуем, кто у нас поближе.
Right, so we're waiting for him to join. Maybe there are...
Хорошо, уже связь, говорят, появилась.
Okay, so we have the connection. Valentin, you have the floor. I beg your pardon, esteemed Jolimbet, dear participants to the international conference, dear ladies and gentlemen. As the declared topic suggests, I have the opportunity to put forward two fundamental concepts in my report. First of all, this is the nature of the international legal relations and the regulators in this domain. Various scientists have given various answers to these questions. The relative progressivism, Professor Alexeyev developed the viewpoint that was replicated by many scientists out there. He wrote that the legal relations presume legally stipulated norms of relations. So the conclusion was drawn by the authors of the Encyclopedic Dictionary. The legal relations are the regulated relations in the legal domain. Another Soviet classic, Professor Alexandrov, way back in 1946, he made a famous speech at the Moscow Law University. He provided more clarifications. The lawyers have the legal norms not arising out of economic relations, but arising out of the formal formation of the state. The law must be based on scientific provisions. I believe it is only expedient to discuss the logic arising from Professor Alexandrov's statement. Not all the relations are governed, only one type of it, The legal relations, however, many scientific works make a mistake about that. Also, in logic, the concepts which are largely or completely overarching are called compliant. There are various types of relations. There are notions of higher volume, the subordinate concepts. In this case, the notion of civil relations is subordinate to the legal relations concept. I believe that in the law, theory, and in practice, there is all the time there is mixing of social regulators of relations and the legal relations. So this is the foundation of my points. At the same time, the legal relations, and this is my important conclusion, they must be governed by legal regulators, and not, as Professor Alexeyev believed, and his multiple followers, is not regulated by law solely. The opponents of this theoretical approach normally express doubt and ask, who is the legal regulator in this type of relations, not stipulated by law and not found elsewhere in the legislative framework? I believe that it's highly important and conceptual to answer this question for us, and judging by the presentations by previous experts, it is only possible to answer this from the integrative law positions, where law does not only encompass legislation, but also the national legislation, but other norms of international and supranational laws. For example, the custom law. I believe that it's necessary to identify two types of legal relations, scientifically grounded and scientifically determined. The scientifically grounded type of international relations is synthesizing equal rules of international relations. In principle, the norms of international cooperation, national international cooperation. Another type, integrative concept, widely spread in the world, is the synthesizing of ontologically different regulators of civil relations in general, both legal or law-related and others. We know that the rules of justice, decency, reason, judicial acts that have been discussed are also part of this. As a result, the right is undefined, is poorly defined, and the judicial practice becomes controversial and unstable. To conclude my brief statement, I would like to summarize as follows. The right in the world, the law globally, and the law in our Eurasian Economic Bloc is following the historic spirals. When the states were autonomous, when each state was trying to regulate its legal relations, internal legal relationships by itself. The member states, part of the EAEU, are in the transitionary period of the development of legal relations from autonomous states internally to integrative space, to establish the law of the Eurasian Economic Union from the scientifically backed provisions and avoiding the counterproductive new conclusions that I've mentioned. I suggest the following: to create a task force to prepare a new international treaty on the law of the Eurasian Economic Union from the position of scientifically backed integrative understanding or concept. I've listened to the colleagues that have taken the floor before. A similar proposal was put forward by multiple attendees before me. Should this be accepted, the University of Law, the University of Justice is willing to take the most active part in developing or drafting the same. Thank you very much for your attention. Thank you, Valentin. We've listened to your proposals with interest, and we will cooperate with you and your institute, your university, to develop this further. I'd like to clarify to the attendees, unfortunately, Sergei Glazyev fell sick, so he was unable to take the floor first, as the agenda suggests. The next person to take the floor would be Mikhail Galperin. He is the representative of the Russian Federation at the European Court of Human Rights, Deputy Minister of Justice of the Russian Federation. His topic is entitled Approaches to Judicial Interpretation in Constitutional and International Justice. Mikhail, the floor is yours.
Good afternoon, respected colleagues, respected Mr. Baishev. I'm pleased to see all the colleagues. Well, much to my regret, I would not be able to replace Mr. Glazyev, but on the topic of the judiciary and administration of law, I'd like to share certain things. And here, would like to continue what Valentin was referring to, this business issues related to development of law and interpretation of law. I'd like to pay your attention in the nearest couple of minutes and speak about the business interpretation and political issues on international justice. It is known that courts and international arbitrations face very often with issues that might be considered as political. As one of the founders of the modern international law, who is court Judge Gish Lauterpacht, has been writing in the 1933, and the citation just asserts that all international disputes are of political nature, so that all international disputes are also of legal nature. For the time being, as rule of law governs that might be solved legally, its political nature cannot be making sure that it's regulated through legal ground. Any loud or important international process that is attracting a lot of attention is related to politics. International arbitrations like Philip Morris companies that are related to toughening by Uruguay and Australia of the national anti-tobacco regulation, as well as the complaints on international complaints of Ukraine, Georgia against Russia on international human rights. Then the Transnistria case, where the International Court has expanded the horizon of Article 1 of the International Convention of Protection of Human Rights and adopted the burden of deferring the political impact of one state over the territory of another. Literally, in the course of the last year, a portfolio of the political cases in the European Court of Human Rights, there has been added interstate complaints, Liechtenstein against Czech Republic, as the withdrawal of Mr. Beneš, property of Germans in Czechoslovakia in 1945. This complaint against the Netherlands against Russia due to this downing of the MH17 in Ukraine, and other international cases where applicants push international courts to express their opinion in the relation of issues that are normally resolved through diplomatic issues, the summons of the heads of states and their sovereign discretion of the national governments and parliaments. It's not a secret that all these issues, as a rule, are directly related with the limits of competence of the appropriate international courts and arbitrations, not only merely in the procedurally, but also with the general issues of the rule of law, national sovereignty, division of powers, democracy, and the authority exercised by the people. And then in May 2020, the Constitutional Court of the Federal Republic of Germany has loudly expressed itself, admitted non-constitutional the measure of the European Investment Bank aimed at stimulation of the economy of EU by channeling and funneling resources. That Constitutional Court of Germany was contrary to the Luxembourg Court that considered these measures of the European Central Bank legitimate and appropriate. The Constitutional Court of the Federal Republic of Germany disagreed with this and has referred that Constitution of Germany, the major law of, doesn't enable the German authorities to offer sovereign powers to EU, so that EU has independently exercised or created new competence for itself, and mechanism and limits of the judicial powers, including monetary and financial sphere, that was part of the case, should satisfy democratic principle requirements. And the court indicated that it's necessary to keep that Bundestag, the German parliament's considerable freedom of consideration in the sphere of its budget powers. As Constitutional Court of the Germany, effect of these measures might result in the bubbles emerging in the real estate and financial markets, affecting negatively living standards of citizens of Germany, as they have been related to emission of euro in the EU zone, might have been touched. Then responsibility to European integration. The court indicated that the constitutional bodies of the Republic of Germany have to make active steps against these measures, minding that the program of the EU, in the opinion of is ultra-viral, so this getting outside the scope of its competence. Accordingly, Constitutional Court of Germany banned any bodies, any courts at the territory of Germany to comply with these requirements and take part in its implementation and execution. The attitude referred that supranational bodies have to take into account the division of powers principle in the corporate states, their powers solving the issues of settling disputes of political nature, not only execution of international liabilities, as well as adoption of it. In this respect, one has to pay attention at Article 46 of the Vienna Convention on International Law. Very often it's referred to that from the one hand that deprives the right that the state, consent of the state, or the compulsory nature of the international agreement was expressed in violence, in contradiction to the international domestic law, but as well as the violation of the domestic law was evident and was related to provisions of special importance that it was indicated in convention. This kind of norm includes the provision that is determining the basis of the constitutional construction, that it's not only material and legal norms that we might express, the norms that are evidence for specific subjective rights. So Anchugov and Gladkov against Russian Federation, that is selective right, and Markin at the right of the military man for the paternity leave, that the protection in the court, principle of division of powers, including the division of powers between the president, the government, the parliament, in implementing foreign economic policy, mechanism of control of powers in the court and judicial field, and other authorities and powers that are related to the procedure of execution of the state's powers. The thesis that I have been referring to earlier in no way could raise doubts that unconditional obligation of the states to respect and compliance with international law, the decision and verdicts of international courts. Attention was paid by the Constitutional Court of the Republic of Germany in this decision that I referred to, that responsibility to development of international law, reaching the objective of international agreement would be part of the national bodies, including Supreme Courts. These bodies have to react in case violation of basic norms of international law, provisions of international agreements and treaties, as this ultra vires that's getting out of the scope of competence, compulsory, say, arbitrary application of international agreements, and not only in contradiction to the national and constitutional construction, but as well as contrary to the essence of the international law, international agreement. And the verdict of the Constitutional Court and decision of the Constitutional Court is responsibility of the Parliament and the government for the European integration in order to protect this integration, not only for the national sovereignty. The Constitutional Court has acted when they indicated that they have been getting outside of the scope of their competence. To a certain extent, this position of the Constitutional Court of Germany is crossing out as similar to the case of against UCOS that was considered by the International Investment Arbitration against Russia. Compensation was awarded in the biggest compensation in the international court history, 57 billion American dollars. This case is actively considered in the Netherlands courts, as submitted to the Supreme Court of the Netherlands. Here it is necessary to note that investment arbitration as well as arbitration court of appeal in the Netherlands that have proven legitimacy of the decision have adopted that the competence of the arbitration may be based on the non-ratified international agreement, as was the case with the law on energy charter that arbitration was basing its scope of competence on. In this case, specifically one may say that not only specific provisions of the national law, but the grounds and the basis of the division of power and protection of rights and interests and powers of parliament in the, implementing international policy as well as ratifying and implementing, implementing provisions of the international agreements impacting the life of state. Application of the international law without ratification that was result in ceding the application and then resolving the dispute would be equivalent to the contradiction of the and violation of the right of the independent court, which is part of the Constitution of the Russian Federation, part of the Constitution of the European states, Eurasian Economic Union. In fact, this provision envisages the right, unconditional rights to deal with by the court that is competent by the law to deal with the issue, the law adopted by the parliament rather than the resolution or decision of the government. Generally speaking, this is confidence similar to the provision to the European constitutional human rights courts is based on this practice that in the course of arbitration, in the course of the consideration by the jury, constitutional arbitration, this arbitration would be subject to universal requirements of Article 6 of the European Convention on Protection of Human Rights that envisages the right to fair judgment by the court based on the laws and the acting independently. Specifically the Netherlands, Supreme Court of which is considering the case, and very recently have become defendant on the claim of the arbitration reservation based on the energy charter by the German company that is demanding billions of dollars based on the decision to toughen legislation making use of coal within the framework of the building of the green economy in the Netherlands. Similar claims are filed against Germany worth 6 billion euros based on the introduction by Germany in order to protect population and to protect limitations for the atomic power that follow the disaster on the Fukushima. Similar requirements, similar decisions, evidence that we speak arbitration and investment arbitration that consists individuals evaluate measures taken by the national parliaments in order to protect national interests, well-being, radiation, industrial safety, other measures that are indicated when adopted, when the national constitutions are adopted. What we can expect in the future, what kind the balance can be found between the political issues that require a special legitimization. Well, take into account the division of powers, constitutional fundamental aspects of the constitution and legal aspects that are definitely being raised by the national arbitrations and tribunals and permanently acting courts. We need to admit the presence of the problem, so it's not marginal, it's not kind of shame, we need to speak about it, so that we need to say that political aspects are present in the practice of international courts, which is inevitable, the practice of international arbitrations, and in many respects these issues are risen because of the interpretation, approach into interpretation. So it's the arbitration and interpretation, not only literal, it's extended interpretation, sometimes directly contradictory to the initial concept of the developers of and its essence. And this volitive interpretation that I referred to, that was considered by the Constitutional Court of Germany, resulted in opinion of the Constitutional Court that the European Court of Justice went outside of its scope of competence, where the European Court of Justice and other EU bodies have developed this competence of the phrases of the agreement that were not envisaged and were not aimed at. This was clearly evidenced by the examples of other states, taking into account the national reaction of the legal systems as Supreme Courts, which avoid direct confrontation with international justice, and then stay within the classical paradigm, respect and compliance with international law provisions, but definitely showing the red lines that have to limit the scope of competence of international tribunals. And these red lines are drawn in the sphere of important political interests that I have referred to, and decisions of which, a solution to which cannot be ensured using constitutional mechanisms and appropriate for the democratic procedures, the will of people or its selected representatives. Elected representatives. So that solving this kind of collision and conflicts is impossible without recognizing the problem of the legal issue, to understand what kind of issue can be considered as political. One may say, if roughly designing this kind of what is this, or simply mentioning what are the issues could be mentioned as political, would be difficult to count and or voice. As the first expression, as the first, the issue arising in international agreement that is allowing formal decision of the dispute and then making decision based on the interests of political group or economic group, supporting the position of one of the parties, and of greater importance or greater influence or impact on the court at this particular stage of time. It is clear that the situation described has to be distinct between the unlawful understanding and the interpretation and getting outside of the scope of competence. Tribunal, this was faced with political issue, was probably an idea and a kind of reflection on in this sphere, but I have to answer three questions, major questions that arise. This reputation issue, to understand what kind of level of legitimacy of the tribunal decision in this issue. Would that be considered fair? Would that improve in the long term the image of the court and reputation of the court? An important issue, whether this decision would be implemented by the parties. First of all, by the defendant states. Secondly, the issues of axiology, the value issue. Whether the verdict or decision of the court would ensure reaching the objective that the court was set up for, that it was based on the agreement that is acting on, whether this verdict or decision would promote peace and fairness and democracy and the mutual understanding between the subject of international law, and would suggest or promote a constructive solution of this political issue. And the institutional issue is the third, which is of the same importance, whether this is appropriate, the procedures of the court, of the tribunal, for full and comprehensive investigation of the issue, whether judges are competent enough, whether the court is sure that the decision would be based on the checked and fair, verified facts, and whether this judicial or non-judicial forum is existent to resolve this issue. In conclusion, dear colleagues, I would like to express surety that close cooperation between the national power authorities that are acting on a permanent basis, including the respected court of the Eurasian Economic Union, our integration associations would enable constructive and mutually respectful legal approach to solve these kind of issues. So therefore, laying a solid foundation for economic integration, ensuring protection of fundamental rights of citizens, developing and strengthening of international law. Thank you very much indeed for your attention, and thank you for the invitation for this important and well-represented conference. Thank you very much indeed, Mikhail, for the comprehensive presentation. Certainly issues of division of political powers and judicial activities of courts always have been existent. In ideal world, courts should stay outside the politics. As a matter of fact, there are often cases that political orders sometimes impact on the decisions of the courts. I'm pretty sure that the court of the Eurasian Economic Union, for this kind of short-term life, we have never been faced with this kind of issues, and the court has never been faced with the issue whether this is politics or law, and we have always been finding the solution within the framework of the agreements concluded within the framework of the Union. Thank you very much indeed. The floor is given to Mark Entin, head of the chair of the European Law of the Moscow State International Relations Institute. Pros and cons of trans-regionalization of the law and the EU. So I'd like to underline that Mark is celebrating birthday. He is 65, so celebrating 65. Sorry for disclosing your age. He found time to take the floor and address the participants of the conference. Mark, the floor is yours. Respected colleagues, friends, the best probably present that one may think of on my birthday is participation in the current conference at the highest level possible. It's possible to spend a couple of days and be aware of the recent trends and tendencies to see how the different problems are approached by our countries, what the problems that we are faced with are considered by the most important lawyers. Look, what is taking place from the point of view of the international integration law, from the point of view of regionalization processes? Well, in the course of the recent months, our major attention was related to archaic and anti-democratic show in the United States of America. I mean the election process, and then for a certain period of time we have lost our attention. What kind of drastic changes have taken shape from the point of view of regionalization? So probably the largest event was recently signing an agreement on comprehensive regional economic partnership, and participants there too, to this largest agreement, and a zone of free trade, have seem to be political antagonists. The countries that are pursuing different ideological perceptions, the countries that are competing between themselves in the sphere of strategy, security, and economic development. So that is ASEAN, China, Japan, South Korea, New Zealand, Australia. When we say that this zone of free trade, we are not fair from the point of view of law. So it's much wider format. We speak not only about the reduction of the level of duties, customs regulations. We speak about creation of the definitely long-term, from the point of view of long-term perspective, so fundamentally new law, legal regimes, what considers promotion and attraction of investments. Most important, ensuring such conditions when intra-regional chains of added value are taken out from any limitations imposed by the national legal regimes. That is, in other words, based on examples of comprehensive regional economic partnership, we see how there's soft integration law is developed that is enabling the participant member states and the business more opportunities compared to what the international law is offering. What is taking place before? I mean, without involvement of the United States. they have managed to build trans-Pacific economic cooperation, and they were speaking about it. Revolution is taking shape in the EU, which is, in the recent months, European Union have created prerequisites for the new constitutional crisis, have pushed Poland and Hungary to block decision-taking in what is related to 7-year budget objectives and approval of the plans of restoring the economic of EU that have been shaped or considered, so next generation EU. If the EU would overcome this crisis, then integration within the EU would go up to a qualitatively higher level, new level that is referred to. We speak about just putting together, making common debts that the nuclear of the EU have been against, rejecting the initiatives of the European Commission groups of the states. Putting together the public debts through funding of the plan of revival of the European Union countries would mean that in all countries there would be similar conditions arising of access of small and medium and long and big business to long-term money. And the rating of borrowing would not be oriented at national conditions, it would orient at general conditions within the framework of EU. It is very interesting. Development has taken shape. For the last 30 years, we have not been paying appropriate attention to the development in the African countries. So common market is being created there. Integration processes in Latin America. On top of this, the 10-year negotiation between EU and Mercosur resulted in putting together the integration type of agreement. So that integration group, EU, Mercosur, have agreed. The other thing is, there are a number of obstacles on the way to ratify it and sign the document, but per se, all the examples I've been referring to indicate that soft integration, new regionalization, would be reaching the objectives of integration without creation of supranational institutes and supranational bureaucracy. So that regionalization is developing very rapidly. In these conditions, Eurasian Economic Union finds itself in the general trend. We are part of we are one of the leaders in this respect, and irrespective of all the failures and mistakes that have been made, irrespective of the criticism that has been arising and expressed by politicians and lawyers, it's of great importance. Let's ask ourselves a question. If we diminish our achievements in the integration process, might that result that we would be shaping out or falling out of a general trend? We would impact damage to population and the economy in general, rather than making use of the huge opportunities that are arising. Naturally, in the interests of all our countries, our population and our business is to strengthen Eurasian Economic Union and support the activity of the Court of Eurasian Economic Union in this respect. In this case, we will have to find solution to a very comprehensive, complex and important issue about the relation of the law in the Eurasian Economic Union with international law. Theoretically speaking, the part of the statement of the chairperson of the Court of the Union has been dedicated to these issues. It was underlined that the law of the Union is an independent system of the law. International law Let's evaluate it. It's the largest achievement of the humankind. It was set up during centuries. It was polished, improved, has been receiving new impetus after each new conflict, new war, and it's evidence that is the legal regulation of the democratic, equal, equitable and fair organization and construction at the level of international policy and relations. Protection of international law is a general task that should be set to our states. What is taking place in the sphere of international law? At present, international law has found itself under threat. More and more instruments are used at imposing of national norms to other states using the extraterritorial principles, secondary sanctions, getting out of the existing legal regimes, creation of the new legal regimes, and so on. So it happens that the situation is taking shape in the sphere of international legal regulation when more and more international law is replaced by extraterritorial activity of the law imposed by certain countries, which is not only considered as extraterritorial law that are pursuing this kind of policy. This state push or make as existent or actual the norms and provisions that they establish themselves. In order to protect international law, there are many methods existent. We need to talk, we need to discuss, we need to negotiate, we need to strengthen the existing regimes, we need to work and to be in advance, and then using a lot of tools and instruments. So there is perspective in new, which deserves greater attention on our side. Look, why interregional integrational law is offering more perspectives for the states that are participating in the integration processes compared to international. The answer is we are going further in terms of legal regulation rather than the minimum that is established by the international law. International law is split into two elements. So the sacred part, principles of law, in international law, the basis that is used to build, the Charter of the National UN, and existing international law in relation to which integrational associations offer more advanced decisions and solutions, and it's absolutely different position and perception of the issue that there are contradictions between the norm of the integration law and norm of international law, which is part of the integration law, and the norm of international law. In order to comply, as legal regulation within the integration group or within the zone of free trade plus, or soft integration would be more modern compared to the set of minimum standards established by the international law, then we have an opportunity using or forming, developing legal regulation between the integrational groups, reach or achieve the second contour of the legal regulation that would assume the best that is existent in the international law, and at the same time would suggest more perspective solutions from the point of view of developing common economic space, legal space, humanitarian space, and moving along this way, we might simultaneously, in relation to what is related to justice, to find solution to the problem that Deputy Minister of Justice of the Russian Federation, Mr. Galperin, was voicing. Indeed, courts are brave enough or have to assume responsibility to a greater extent political issues or political disputes. But what EU has done in this respect? Two absolutely different decisions or verdicts in this respect. First, verdict of the court of the EU that is banning the states, members of the EU, to offer cases for arbitration, and business entities to offer cases for arbitration when it is spoken about application of norm and law of the European Union, because the monopoly of interpretation of the law and provisions of the law of the European Union is given to the court system, legal system of the European Union. And the other aspect, take a look in hundreds of agreements that EU has concluded with third countries in sphere of trade relations. They have provisions of the state and public and private arbitration. When it was mentioned that this mechanism is included in the failed agreement on Trans-Pacific Partnership, so all businesses of the EU were against including these provisions into possible future agreement. The European Commission has conducted polling of the opinion of businesses of different, so medium-sized, big businesses, and have received approximately 1,500 negative opinions and conclusions related to this particular mechanism. Therefore, it is important so that the court system or the legal system of the Eurasian Economic Union, as is taking place at present, would protect and defend the right of the, say, the law of the Eurasian Economic Union as independent law. And we have thought how to do, or how to make sure that first, when we assume certain obligations and liabilities, our states would not add or would not create any additional obstacles for functioning of the general economic space of the Eurasian Economic Union, from the one hand. From the other hand, not only orient themselves at maximum favorable legal regulation of economic, energy, transport activities, financial activities, and so on, would rather create or ensure this kind of integration standard that we could have used as the foundation of the transregional law being developed, that in perspective would regulate relations between the regional integration groupings of the soft and hard law. Thank you for your attention.
Thank you, Mark. Once again, our congratulations on your birthday. The court has given you a present, a birthday present, as you've mentioned. Thank you for your opinion in the trans-regionalization trends. It's very important for us to get your opinion, both from the viewpoint of theory and practice, as to how courts operate now and in the future. In order to have practical aspects covered, I believe the floor should now be given to the head, to Ms. Barsegyan.
Спасибо, уважаемый Жоломбет
Thank you very
Нурахметович,
much,
уважаемые
dear
коллеги,
Жоломбет,
участники конференции. Позвольте в
participants
первую
in the
очередь
conference.
поблагодарить за
First of all,
приглашение
I would
принять
like to thank you for the
участие и
invitation to take
приветствовать вас
part
на сегодняшнем
invite
мероприятии. К сожалению,
and to
Сергеевич не смог лично сегодня принять участие.
Unfortunately, Mr. Zadiran was unable to take part in today's discussion.
За прошедшие 5 лет
Dear colleagues,
мир
I would say
значительно изменился.
that the world has changed over the past 5 years. Global challenges have strengthened global challenges for the Eurasian Economic Union countries, and the existing integration level is insufficient. In these conditions, enhancing the cooperation mechanisms in the Union, making them more adaptive and flexible to ensure internal development, ensure the strengthening of cooperation and interaction of our countries, strengthen the EAEU's position as an independent entity in the global arena, capable of influencing the global order and representing the interests of the member states as a single bloc. Recognizing the current challenging conditions and striving towards shaping innovative Eurasian space, digitization of economies, stimulating business activities, and ensuring positive changes in the life of our citizens, the Member States' heads have determined the vector of the following developments of the Union. In 2018, in December, there was a declaration adopted on further improvement of integration processes in the EAEU. In 2019, according to the Council's decision, the EEC, together with the Member States, has set down to develop the agenda until 2025. One of the ideas, well, basically, these ideas were largely adopted by the Member States, approved by the Member States. We plan to approve this document, this final document, at the session of this Eurasian Economic Union's Council. Well, first of all, it's a large document that we're talking about here. It comprises 332 mechanisms and tools grouped in 11 system blocks, system categories by all the activities in the EAEU. We believe that it will take 13 international treaties to be developed, 60 pieces of legislation of EAEU, and around 30 amendments to the EAEU treaty to make it happen. So therefore, we're talking about a serious legal transformation that will touch all the directions, all the regulation spheres and domains. We plan to complete the formation of the shared market of goods, services and workforce through gradual, incremental removal of obstacles in the internal market of the EAEU, further liberalization of services, development of single settlement space, and the centralization of state procurement. Thanks to the formation of the exchange-based goods exchange and energy markets regulation, the regulation of the single market of the EAEU will be improved. A brand new level will be seen in customs regulation and administration. Also, the strategy involves a large number of measures and mechanisms geared towards ensuring quality and safety of goods through implementing an efficient tool to comply with basically using the best practices when handling the goods. The digital space will also be improved. It will be created and further enhanced through the creation of the fully integrated information system within the EAEU. Also, activities are scheduled to modernize and ensure cooperation, boost competitiveness of national economies of the member states by forming joint financial and industrial groups and Eurasian multinational corporations. The agenda also provides for the empowerment of citizens healthcare, tourism and sports are particularly reflected. I would also like to identify another strategic block, boosting the efficiency of EAEU institutions. Customs union, single economic space, even initially we saw that there is a higher efficiency of the operation of these institutions. At the same time, to ensure deeper integration, we need to enhance the mechanisms underpinning it. A series of the events is planned to that end to boost the efficiency of the Commission's activities. Monitoring on the compliance of the EAEU law, the rights to go to court, particularly when Member States fall short of complying with their obligations on the commodities exchange in the market, as well as the states being able to go to court if Member States fail to comply with their obligations in the internal market. Also, it is planned to create and establish a mechanism that provides accountability for the officials should they again fall short of complying with the legislation of the EAEU. At the same time, new methods, new ways to improve the legislation are sought should there be any economic disputes between Member States. These mechanisms will be improved. The creation of the mechanisms of mandatory enforcement of the decisions of the EAEU Court. The development of mechanisms of picking and vetting the judges of the court, as well as boosting the qualification requirements to the judges. All the listed measures are first and foremost geared towards compliance, mandatory compliance of the EAEU with the EAEU legislation. All of this will contribute to developing the EAEU along the approved vector of development, and it will also boost the efficiency of the bloc in general. As I mentioned, a number of strategic changes will require the amendment or will require amending the treaty of the EAEU. Particularly the Department for Integration Development that I'm heading is the coordinator of the activity to improve the treaty. Member States and the Commission are constantly involved in this. Now we face yet another important challenge. We need to implement, or we need to eliminate a number of gaps in the strategic directions, some gaps in the treaty. It will take quite a lot of work, quite a lot of effort. However, this will start after the document regulating this will be signed by the Member States' heads. However, the amendments are being prepared as we speak. Colleagues, I would like to say that strategic developments is the key foundation document of strategic planning. It outlines the logic of further cooperation, shaping the mechanisms to implement existing agreements, geared towards deepening and enhancement of integration processes, brand new approaches that help promote towards the implementation of the goals of the Union within the shortest time frame possible. Thank you for your attention. Thank you for the report. Thank you for your report. Definitely, whenever we're talking about boosting the role of the institutions in the EAEU, well, this is highly important. This is critical. At the same time, there are measures offered to improve the activities of the courts of the EAEU, such as selection and appointment of the judges of the court and members of the apparatus. We should not forget about the principles of impartiality and the independence of judges and the judicial system as a whole, and also the necessity to maintain the stable operation of the court and
суде соответствующего государства-члена.
Basically representing the interests of the member states adequately. This also suggests that the interests of the member states when appointing the judges should also be taken into account. The current procedures on passing the candidates and approving these candidates is well-grounded, so there are doubts whether this procedure should be changed. Sergei Zadiran is given the floor next, First Deputy Minister of Justice of the Republic of Belarus. Dear Mr.
2020 год ознаменовал собой начало второго пятилетия Евразийской интеграции. Любая форма интеграции, будь то единое экономическое пространство, таможенный или экономический союз, направлена на достижение первоочередной и, по сути, единственной цели – упрощение торговли между государствами в целях обеспечения благосостояния
The Eurasian Economic Union is the main economic union for its members. 4 out of 5 current EAEU member-states are also members of the World Trade Organization, which also seeks to create a separate regime for economic and trade activities. Finding the right balance between different commitments in similar areas is not always easy. Taking into account the ongoing pandemic and the need to overcome it so as to restore the economic potential of states to the pre-pandemic level, integration processes as a safety net play a special role. In this respect, the agreements must be backed by clear intentions of the participants to adhere thereto and to implement them. Unfortunately, more often than not, we are witnessing a certain declarativeness and not the obligatory nature when handling the adopted integration decisions. In general, the Union has proven itself worthy in addressing the challenges posed by the pandemic. The integration work did not cease. It began to use even more the possibilities of the online format. At the same time, the member states of the Union adopted a number of decisions of integration interaction to combat and overcome the consequences of the pandemic. At the same time, we see lagging behind some deadlines when shaping specific markets and introduction of new barriers to trade. Of course, many plans for the development of integration were disrupted by the global pandemic. However, it must be understood that along with the objective economic impossibility of fulfilling certain agreements on time, there are still special subjective reasons for the Union member states to delay certain integration processes. On the eve of the adoption of the strategic directions for the development of Eurasian economic integration until 2025, identifying pitfalls is a necessity that will allow us to anticipate the emergence of problematic issues and to channel all our efforts towards resolving them. The EAEU partners perhaps should take into account the priority of the Eurasian integration processes, base their decisions on the goals of integration, the previously stated and agreed scales of integration processes. In general, it seems important at the institutional level to determine measures aimed at realizing the potential of the EAEU. This also applies to the judiciary. In our opinion, the relatively small number of cases considered by the court, up to 10 per year, may indicate an insufficient workload upon the court. As a rule, decisions taken in cases and advisory opinions are accompanied by a significant number of dissenting opinions of judges. The court must achieve a complete, objective and fair resolution of the case. In this regard, the decisions accompanied by numerous explanations, deviations from the adopted position, to a certain extent weaken the credibility of the court's decisions. It is believed that the key to making the court more effective lies in its competence. At the moment, the court does not have jurisdiction to award compensation in the event of a breach of obligations. The court's decisions fail to create or change the existing norms of the Union's law. In this regard, going to court is relatively safe for the defendants. Hence, inefficiently may indeed result out of limited powers of the court. In fact, many of the member states' evasions from the implementation of agreed decisions in the field of Eurasian integration do not receive proper evaluation. This creates destructive practices and a deceptive perception, a twisted perception of the permissibility of misconduct. In order to determine the prospects of the development of the court, the composition of the subjects acting as plaintiffs in the court should be considered. At present, states do not so often resort to the services of the court to resolve disputes. This tendency may serve as a message of a certain distrust of member states towards the court in terms of dispute resolution. At the same time, appeals in connection with the request for an advisory opinion of the court are used quite often. In general, there is nothing wrong with this trend. This should draw our attention to the transformation of the vision of the role of the court and encourage us to think about changing it. The existing workload of the courts, unfortunately, does not go to indicate that there are no controversial issues in the EAEU. One of the possible solutions to strengthening the role of the court in resolving contradictions within the Union is the proposed vesting of the board of the Eurasian Economic Commission with the right to go to court. This may take place in case of non-fulfillment of decisions of the Union's bodies in the part concerning the fulfillment by the Member States of obligations within the framework of the functioning of the Union's internal market. Should this proposal be supported, will we be able to witness a new practice of applying to the court. The Commission will, in fact, be empowered to apply to court on the same issues, on the same matters that states can now address. It will become clearer whether doubts about effectiveness are a key reason for states not to apply to court. Take into account the active international activities of the Union, possible disputes between EAEU members or the EAEU as an independent entity with third countries are not excluded. Against this background, it is all the more important to ensure the effectiveness of the judicial branch of the Union at both the institutional and law enforcement levels. In general, to ensure successful developments and the declared deepening of integration within the EAEU, it's necessary to bolster the role of the court as a platform to resolve disputes and the kind of a controlling mechanism of the fulfillment of obligations. Without making the court more attractive in the field of dispute resolution, including for business entities, ensuring further economic growth in the EAEU is seen as difficult. Eurasian integration, first and foremost, is the economic ties between the subjects, between the entities. The maintenance of these ties depends not only on a developed legal framework, but also on the effectiveness of protecting the created economic ties. The court is the only statutory body of the EAEU with such competence, and in our opinion should take into account the dynamics and the development of economic relations when improving its work. In conclusion, let me express my confidence that a rich agenda in diverse topics will provide an opportunity to consider all relevant aspects of Eurasian integration. Thank you for your attention. Thank you very much, Sergey. Definitely it's difficult to dispute the fact that the role of integration bodies must be heightened, must be improved. At the same time, the opinions of various member states representatives as to workload and the number of cases considered by the court are not exactly in line with the actual workload of the court. Because the court considered in an international court does not amount to the court, or it is not equal to the court handled by a national court. At the same time, I wish to say that the court of the Eurasian Economic Union is not lagging behind other international courts with the number of cases handled per year. The number of cases resolved and the number of advisory opinions provided suggest that the court is full-fledged, is fully compliant, or is fully implementing the objectives set forth before it. Protection of the legal framework of the EAEU. Definitely more workload is possible. There are other ways to give the entities pathways to go to the court of the EAEU. However, international courts, when handling cases, are proceeding both from the viewpoint of national and international law and analyzing the big picture, the main components. So it would be difficult within the framework of this court, as we have it now, to implement it properly. I would like to give the floor to the next speaker. She'll be talking about the efficient state service as an element of institutional system development.
Добрый день, уважаемые
Very good afternoon, respected colleagues. Well, first of all, I'd like to express gratitude to the previous speakers for the interesting and informative for the people that working in the sphere of application of law in the sphere of the EAEU. The topic I've selected is important. Irrespective of the slowing down of the global economy, the long-term trends of the international relations are at the high level, staying. So these trends result in the necessity of deepening the cooperation between the states. That in turn would ensure proliferation of international mechanisms ensuring this kind of cooperation. The difficulty of such mechanisms grows there where the efficient activity might be ensured by the international organization, within the framework of which the working bodies ensuring the achievement of which would be provided by the high-skilled specialists and international civil servants. As it is known, one of the international organizations like this that has been acting, that's the EAEU, that has set up the system of bodies. But only two of these have their own staff that's permanent, pending the commissions and the court, where at present they employ approximately 1,100 officials and servants. One of the strategic development of the Union until 2025 that should be considered as the improvement of the supranational bodies of the Union. In this respect, the institutional role of the Commission has to be expanded when we listen to the presentations of the previous speakers. As it is known, it is suggested to include the strategy that might result in creation of the new working body within the framework of the Union. The major focus is made at the institutions of the Union per se. At the same time, it is practically not mentioned about the staff that is ensuring this kind of activity. A minimum attention is paid only as reference when people are switched to short-term contracts. Third cycle of its development, in 2024, the cycle would be renewed, both for the Commission and for the Court of the Union. And this would go through the whole lot of the professionals. By this time, the civil service of the EAEU should not be considered as something temporary, but as some kind of career for high-profile specialists. That envisages that all legal aspects of international civil service within the framework of the Union should be clearly regulated. Inter alia, from the point of view of protection of rights of such servants. Development of such mechanisms, first of all, should proceed from special nature of the civil service, in particular the service in the EAEU. Major feature of this international civil service that is offered by special nature of labor relations with international organizations, and the essence of that is separated from the will and then decisions of the state bodies is its independence. Administrative Tribunal, in decisions of the 2003, it mentions that independence of the international civil servants is the major guarantee of appropriate functioning of international organization. Independence is not something out of the real, so it's full of practical sense. It's ensuring that the state is not instructing the staff of the organizations, is not impacting on the decision-taking. At the same time, civil servants would not consider this kind of instructions, would not proceed from the interests of the state, but rather than from the interests of the organization. So it's included in privileges and immunity by the EAEU, which is part and parcel of the agreement of the Union, according to historical norm that is reflected in its international agreement. So this independence of the function is ensured, in particular functional immunity, so that is excluding the influence and impact of the national law, and then including the country of residence. So this is part of the labor relations. So consultative opinion in the June 2018 internal law of the organization regulating international civil service is aimed at excluding the impact of the national law on the civil servant. As a matter of fact, independence of appropriate civil servant is ensured while decision-taking. within the framework of international organizations is of recommendation nature and is not referred to the member states' law, including the state of residence. Some organizations limit application of national law in considering the disputes involving the international civil servants, based on the idea ensuring functional immunity of the organizations and servants. At the same time, there are situations when regulation within the framework of the organization is not appropriately developed. So it has of lacunas, and to a certain extent it also has references to national legislation. At present, the law of the EAEU is actively developed, inter alia, legal and interdisciplinary relations between the civil servants and officials. The law of the Union established appropriate rights. Internal law is developed on the basis of the agreements, so that's on the whereabouts of the Union states. However, many issues of the labor relations are not regulated. The law of the Union is referring to the provisions of the national legislation. The Court of the Union considered a number of times that internal provisions should be developed within the framework of the Union, getting out of the regulation of internal decisions of the organization by the national law provisions. Labor relations and the internal legislation might result in differentiation and difference of the legal status of the individuals which take similar or equal positions. We know that bodies of the Union, Commission and the Court are located in different countries, which is violating the principle of equality, principle of efficiency of functioning of the international organizations, which is also evidenced by the experience of classical international organizations as well as other international associations. Labor relations of the civil servants should be regulated by internal provisions of the international organization. Efficiency and development of the Union as international organization has to be put in doubt based on its unique status. Is close to impossible. The regulation of labor relations by any norms definitely raising issue of protection of rights of civil servants in case this kind of norms are wrongly implemented. The UN Court that administrative tribunal of Bake in 1954 that would provide activity and mechanism of the protection of servants arise from the major interests of the organization. The right to legal protection is the part and parcel of any status of any individual, inter alia, civil servant of international organization. And it was evidently and fairly stated by Grigory Vasilevich, protection and defense of legal is functional as an impartial right of the individual. Secondly, interstate practice that judicial and court protection is universally recognized international provision. Neither court of EAEU nor any international body is empowered to consider disputes between the bodies of the Union and civil servants. National jurisdiction are not efficient. International civil servants, based on functional immunity of which the refusal to recognize, it should be only based on the voluntary attitude. So the civil servant of the Eurasian Economic Union, EAEU, is short of protection of its rights and has a legal status and an efficient access to international justice. Take into account their status and functional and immunities of international organizations might be considered only by international level. It is necessary to pay attention that the existing mechanisms and the legal issues are of serious limitations. Commission of Ethics that is created at the Council of the European Commission is having powers, and when disputes are considered, their powers are limited. Normally personnel, staffing issues that are partially reflecting the spectrum of the labor relations, and as a tool is a kind of alternative to court consideration. And its nature doesn't comply with the criteria of independence. Whereas EAEU consultative function of the court has proven its importance and not considering the individual decisions, evaluates to regulation and the civil service in general, including promotion of the law of the Union. It of the same power as consideration of the disputes, but it's not fully fledged mechanism that is ensuring protection of civil rights, rights of civil servants. It's not of compulsory nature, and de jure may not result in restoring the violated rights. We raise an issue on the very short range of individuals that are entitled to apply. Based on Article 46 of the court considers cases of violation of rights of the civil servants of the Union. So, in fact, issues rising on the competitive basis to be employed, but has not yet become the employees. As the lacunas in the law exist, in temporary limitation of right of conclude the short-term agreement, this kind of people are actually dependent on discretion, and they have not access to consultative function. It's impossible to mention about any approach to protect the rights. Analysis of practices of other international organizations, and then consideration of the nature of the employment may arise in conclusion at the extended right number of people that have access to court consideration and then the protection. Eurasian Economic Union has civil servants should be including descendants should be who have been subject to selection and who are entitled to conclude an agreement within the EAEU, but have not yet concluded the labor contract. In conclusion, I would like to note that efficient protection of rights of the civil servants should be quite competent in considering the labor relations. That also should also involve in guarantees applied by international organizations. Protection of rights should be resulting in verdict compulsory for implementation and should aim at restoring the violated rights. In this respect, development of the competence of the court that are aimed at solving the labor disputes would be highly desirable. Alternative options related to consideration of labor disputes in the court and the national jurisdiction bodies would place the Union as international organization in an unfavorable situation when choosing the protection of rights of civil servants and the organization itself. So thank you for your attention. Thank you. It's important message. The protection of civil servants' rights within the framework of EAEU activities are always important. They're always in need, and they're always of practical implementation. I would like to simply mention, so when you mention the figure of 1,100 that are employed by the bodies of the EAEU, so you put together the Commission and the Court. For the listeners who are unaware, I would like to underline that the court of the EAEU employs only 60 individuals, including 10 judges. So compared to the Eurasian Economic Commission, we have much less people employed. The second problem, or the second issue that need to be revised, need to revise all acts and regulatory framework adopted by the EAEU, which is also regulating material, social, and other type of protection and of these two bodies' employees. As a manager, I always often face sometimes the issue of employment. Issues of guarantees are different, even though we have the two bodies equally competent within the framework of the activities of the EU, and the civil servants have the similar or same status and should be, as you mentioned, rightly mentioned, noted, should be equally treated. But in practice, it's not always the case, unfortunately. The floor would be offered to Elena Babkina, head of the chair of International of Private and European Law, of the Belarusian State University. The topic of its statement is strategic development direction until 2025 as the legal norm to remove barriers at the market of the EAEU. The floor is yours. Thank you. Good afternoon, respected colleagues. On my own behalf and on behalf of the Chair of International Law of the Belarusian State University, I'd like to express my gratitude to the Court of the EAEU, in particular Mr. Paishev, all the Secretariat of the Court, for the organizing of such interesting and important, take into account the requirement of the WHO on the social distancing, and then also ensured and organized by high-tech level. Application of IT is also an inalienable part of relations. And this year, when we are answering to this challenge of current time, the Faculty of International Relations is developing the curricula of interdisciplinary, distant so based on politics and law and economics of the EAEU. Within the framework of this program, curricula, we are planning to train experts in the sphere of European Eurasian Economic Integration, specialists for the EU, which are in charge of developing the bodies, as well as for legal and economic consultations. Teaching in this e-learning would be also provided by the scientists and people working in the sphere of practice in the European integration, and applicants might be entitled to apply from any member states. Coming to the topic of my presentation, we are speaking not only about the regulatory framework, not only about strategic development, the draft of this document that literally on Monday was approved by the Council of the Commission and would be approved by the highest body in December 2020. I'd like to remind you that obstacles at the domestic market is not only slowing down economic cooperation, but is also importantly resulting in subjective pessimism of participants of economic activity, economic turnover, and then creates negative connotation of the word phenomena of integration. Unfortunately, existence of obstacles at the common market is as a trend. Irrespective of active involvement of European Economic Commission, so we heard of the welcoming address of the Collegium, the chairperson of the board, Mr. Mesnikovic. Irrespective of activities of the board or Collegium aimed at revealing and elimination of the obstacles, their number is not decreasing. Even if we take into account the registered obstacles, when I speak obstacles, the obstacles that are included into register of obstacles that we see at the site of Department of Existence of the Internal Markets of the Commission, then qualitatively speaking, a number of obstacles, if we compare 4 years ago and current state, the situation has not changed. If at the late 2016, this register has recognized 60, out of which 9 barriers, 34 limitations, and 17 exemptions. Then within the framework of 4 years, the Commission managed to eliminate 57 obstacles, which is a lot of work. But unfortunately, mathematic actions do not result in appropriate 60 minus 57 is not equal to 3. And when we speak about 59, we speak about 59 items which are distributed in a similar way, 11 barriers, 35 limitations, and 13 exemptions, which is the way, they could eliminate the barriers and eliminate other barriers at the EAEU. 2 models of integrations can be considered, positive and negative. Negative, historically speaking, American region. Positive is considered for the European region mostly. Negative model of integration is built on the legal provision of necessity to minimize the obstacles imposed by the state to ensure economic freedoms at the movement of labor force, capital and goods. The consequences of negative integration is competition of jurisdictions when member states compete between each other to establish the best or the most favorable legal regime for economic entities, eliminating administrative barriers in the most sensitive for itself spheres. For EAEU, it will have always been energy market, technical regulation, phytosanitary control, international transportation, and state procurement. Negative integration, in essence, would not ensure appropriate functioning of the highest form of integration that economic union is acting as. As I said, the competition between the member states to provide, to secure the highest, the most favorable regime at its territory. But at the same time, negative integration provides for foundation, the ground for positive integration that is implemented using the tools and instruments of unification and harmonization, that is, within the framework of the common and coordinated policy, if we speak about the terminology of EAEU. And combination of negative and positive forms of integration might result in the draft of the strategic development of the EAEU integration. This draft of this document was considered Strategy 2025, and this fact makes this source as the source of the appropriate law applicable in the EAEU aimed at elimination of the barriers and exemptions at the EAEU market and considering the disputes when the member states violate acts or treaties of the Union. When we speak about Strategy 2025, one has to underline that the unique nature of this act is its sphere of application is oriented not only the existent status quo in the sphere of legal relation, the lege differente. The strategy consists of important elements and mechanisms aimed at ensuring the achievement, objectives and goals of the creation of the Union, established in the treaty, ensuring the new forms are added, but also spheres of economic integration of the member states, which is very important. This kind of the benefit for the future. So the strategy is aimed at elimination of all barriers and maximum shortening and limitations and exemptions are aimed at limiting freedom of movement of goods, capital and work and at the market of the EU. The list of obstacles further, according to the text of the strategy, is clarified for specific branches of the national economy. List of measures aimed at elimination of the obstacles at the market of the EAEU, we could see the following measures: ensuring a common approach in the sphere of application of technical regulations of EU, creation of the quality system of the EU at the common market of the Union. Secondly, ensuring non-discrimination for enterprises of the member states and offering the transportation services. Ensuring common attitude to customs regulation, elimination of exemptions from the common customs, ensuring the equal access to state procurement, information, transparency and openness of the procurement. I'm pointing at the legislator have been operating using the phenomena ensuring, providing, eliminating, which are quite specific and quite concrete. So appropriate expanding of the powers of the Commission might, so Collegium might approach the Court of the Union in case the bodies of the Union's decisions are not implemented by the Member States, liabilities and obligations assumed based on the functioning of the internal market of the Union, as well as empowering the Grand Jury or the Grand Collegium that's approaching the highest economic council in case of failure of implement the court of the EAEU decision in order to take appropriate measures. At the same time, to a certain extent, this integration potential is somehow limited of making the use of strategy 2025 using such wording as ensuring or considering an opportunity. In the context of mutual recognition of bank guarantees, when we speak about ensuring of equal access to the state procurement, it is considered that this kind of wording is considering an opportunity. So this wording that are of dispositive nature rather than imperative nature, so they are not literally interpreted, so therefore cannot impact at reduction of the scope of competence of the Union and its bodies aimed at stating the violation by the Member States of the provisions of the Treaty and other decisions of the Union. As soon as the strategic and permanent direction of activity, the strategy considers full elimination of barriers and maximum reduction of exemptions and limitations for the full freedoms, the Union is entitled to operate using any appropriate tools. Any appropriate tools are available for the justice. So the most important role should be played by the court of the EAEU, which is in charge of control of implementation and compliance within the framework of the existence of the common market of the Union. The model for the court of the EAEU, and this, so the doctrine of assumed powers that was gradually developed and expressed in the constitutional conclusions and decisions of the Court of the EAEU, consultative opinion 2.91, the Court arrived to the following conclusion. So that European Economic Community used to be known like this. The competence of the community might be of exclusive nature, excluding any competition on the part of the Member States, according to provisions of the treaty, or due to the essence of the measures adopted by the institutions of the community in order to implement these provisions. And such competence may eliminate the power of the state that did not have such competence, so that could level down the scope of competence of the member state because of imperative in their actions based on acts of the Union are not established. So the court went further in the consultative conclusion 1/0.3, where it repeated that the competence of the community may not be simply openly described, but also arise of other provisions of the agreement and measures adopted by the institutes of the community in order to implement these provisions. As the community empowered the institutes of with the appropriate powers, and the strategy is aimed at elimination, full elimination of barriers as a strategic and the most important task. And this objective is the objective to achieve specific goals. Then the community, in our case, the Union these days, has the competence to take actions aimed at achieving such goals, even if there are no specific provisions in the regulatory framework documents of the Union. Therefore, the conclusion of my short statement is, even in the conditions of cautious, very careful legal provisions in the regulatory framework of the Union's documents, the court may use mechanisms without which reaching the objectives expressed in the treaty of the EAEU and other decisions of the Union is impossible. So therefore barriers to be eliminated according to the strategy could be considered, not only limitations in the spheres that have been put together by the common policy at present, but there should be considered by any measure of the state that are not compliant with four freedoms, whether this is coordinated policy, agreed policy, cleared policy. This kind of measures can be applied by the Union and its bodies. Thank you for your attention. If you have any questions, I will be pleased to provide answers.
Спасибо вам, Елена Васильевна.
Thank you, Елена. The questions are coming in to our Telegram channel. There is a list of questions. Should there be any ones specifically addressed to us, to you, we will give you the option, the opportunity to answer it. Marat Samsarbayev is now given the floor, Professor, Department of International Law, Gumilov Eurasian National University. Marat, the floor is yours. Okay, thank you very much indeed, dear Sholumbek, for the floor provided. You can hear me, right? Good afternoon, dear participants to the conference. The Eurasian Economic Union has two categories of international treaties, mutual treaties. There are at least 84 international treaties and mutual agreements. The total number of agreements and treaties of the EU with a third party is 7. Since implementation has multiple meanings, I will maintain this definition. Implementation is basically implementing the provisions of the Eurasian Economic Union's treaty in enforcement into practice. The legal basis for the conclusion of mutual agreements by the EAEU Member-States, there is a central treaty dated May 29, 2014, as well as a number of economic treaties of member states, or by the member state, entered into by the member states, and the third parties to these treaties. So, in this case, we're talking about the agreement of May 14th, 2018. The first such treaty was the agreement with the Republic of Vietnam. In 2018-2019, further agreements between EAEU and China, Iran, Serbia, and Singapore were concluded. According to the data of the legal portal of the EAEU, the Eurasian Economic Union has entered into at least 60 memoranda. Out of these, 11 with various departments and institutions, ministries, 17 with governments, 33 memoranda with international organizations, and 12 memoranda with various international blocs. What are the issues of implementing international agreements, and how should these issues be resolved, in my opinion? 84 mutual treaties and 7 treaties of the EU member states with third parties are real. They are compliant with the second article of the Vienna Convention on International Treaties, dated May the 29th, dated May the 23rd, 1969. So if we're switching from exporting crude materials, commodities, and to follow the directions of strategic development until 2025, as outlined by my colleague Ms. Babkina, as well as energy policy, transportation policy improvement, and the very content of these agreements would have helped to facilitate the implementation of these agreements in our practice. I mean, the content of the agreements per se already allows for prompt enforcement of them without any delays or obstacles. This is the first aspect. The second aspect, or second challenge, as I mentioned, 76 memoranda have been made between the EAEU and third parties. Third parties meaning states not members to the EAEU, as well as international blocs and international organizations. So what are memoranda from the viewpoint of international law? Some of our analysts believe that these memoranda have an international meaning. Essentially, these memoranda are just international acts which are not legally binding. Memorandum can mean two things. First, it's an international treaty, and the second definition is memorandum as a declarative act, international declarative act. So the 76 memoranda that I have mentioned are all declarative, meaning that they're not actual treaties with respect to the legally binding principle. This is specified in every memorandum out there. This memorandum is not a piece of legislation, no financial obligations arising thereof out of it. Nonetheless, I wish to say that thanks to the memoranda, other countries will be looking more closely, will be scrutinizing the legal practices of the EAEU when dealing with third countries, free economic zones, the enforcement of legislation on the free economic zones, and thereby these memoranda will turn into actual international legal instruments, legally binding treaties. Third challenge, the matter of self-fulfilling and not self-fulfilling agreements. Everybody knows that in Kazakhstan our international agreements do not fall into the category of self-fulfilling agreements. I mean, the very signing of the document does not cause the agreement, does not cause the treaty, including the treaty of the EAEU, to be valid or to be entered into force in the territory of Kazakhstan. It is also necessary to take an additional piece of legislation, be that an act, a law, to enforce it. Only then would the implementation of the provisions of such an international treaty in Kazakhstan will be possible. As far as we're aware, the same rule applies to other member states. For this reason, I believe that definitely self-fulfilling treaties or agreements is a positive trend, although there are several peculiar notions or peculiar features to them. The matters of legal relations in the EAEU are becoming predictable for us. When they become such, then we can switch to the next phase, to self-fulfilling international treaties. I believe that as early as today, it is expedient for us to think about the feasibility of the development and adopting of such a treaty, for example, within the framework of the EAEU, about the implementation of self-fulfilling or non-self-fulfilling treaties. Every member state could give thought about the development of a domestic law entitled, for example, Status of Self-Fulfilling or Non-Self-Fulfilling Agreements Act, something like that. Fourth challenge, the Intergovernment Council and the Eurasian Council is not clearly identified, their jurisdiction is not clearly identified in the treaty. And that means that the member states must adopt domestic legislation to govern that. I believe it would be nice for every member state to develop and adopt a new piece of legislation on legal relations of national bodies with bodies of international agencies or international blocs, where we could put forward the mandatory nature of compliance with the EAEU body's decision throughout the member states. Fifth challenge, the barriers. Something that Elena has mentioned before me. These barriers are indeed in the way of implementing of our international agreements, both acting internally within the 5 countries, signed and implemented by the member states, as well as those signed by the EAEU or entered into by the EAEU and the third party. So we have a question here, we have an issue here. up to 69 obstacles can be identified that are hampering the implementation of international agreements. If we do the math for all the 5 countries, there's 238 barriers in total. So, to resolve this matter, I believe we should look at, we should consider at the nature of how our legislation operates, domestic legislation. For example, there are questions on industrial policies, there is a lack of definition of transportation laws, or lack of clarity, or lack of pieces of legislation. They're not, when they exist, they do not comply with the Eurasian legislation on the same matter. Veterinary and phytosanitary domains lack harmonized quarantine measures, application of quarantine measures, which is also hampering the implementation of several agricultural or agriculture-related treaties that are in place and that have been signed within the bloc. Therefore, I believe, or I would put forward the following suggestion in the light of these barriers, in the light of these obstacles. Maybe we should adopt an international legally binding agreement titled "The Detection, Prevention and Elimination of Barriers, Omissions and Limitations Hampering the Implementation of International Law and the EAEU Agreements." Pain point number 6 is related to the court of the Eurasian Economic Union directly. Probably it would be nice if there was a legal execution of the right of the Eurasian Economic Union to go to court, to go legal formalization of the right of the Eurasian Economic Commission to send applications to the courts of the EAEU on improper execution or non-compliance by a member country of decisions of the EEC bodies on the need to implement the treaty on the EAEU implementation of international treaties. Number 7, the court could adopt the advisory opinion on the interpretation and application of international treaties of the EAEU, entered by the EAEU. In addition, the court should be empowered to make decisions on issues of non-execution or improper execution of international treaties, on the possibility of imposing penalties on one or another authorized state or other body of the EAEU member country non-compliance to cause them to properly execute. So basically, this will enable better application of the Eurasian laws. Thank you very much for your opinion. See you. If there are any questions, I believe that I can take them now or during the discussion stage. Thank you. Thank you, Marat, for the content-rich talk. Your proposals will definitely be looked into. There will be a directory issued summarizing the points voiced during the conference. I believe that your suggestions will be reflected in this work. The questions are coming through Telegram, to our Telegram channel, and should there be any coming your way, we will give you the opportunity to answer them.
So we'll give the floor to Andrei Demendiev, the senior lecturer of the... So the topic, interrelations between the strategic development of the Eurasian integration and MDG of the UN in the Eurasian region. So Andrei, the floor is yours. Very good afternoon, respected colleagues, respected court. Well, first of all, I'd like to express my gratitude, first of all, on my own behalf and on behalf of the chair of international law of the Russian University of Friendship of People, taking into account the opportunity to take the floor at such an important event. Well, to avoid repetition that colleagues have been referring and touching to provision of the strategic developments of the Eurasian integration and how they would impact this or that aspect of our life, of the court and the union itself, I would like to point at major concepts and ideas and perspectives from the point of view of the regions implementing or reaching the MDGs of the UN. We all know very well that in 2015 these objectives have been adopted, established, so the 17 objectives, very fundamental, very important, so that are dedicated that everyone in this world lives a better life. Specific objectives are set, and then specific deadline is implemented until 2030 to be reached. The governments, the states of the EAEU are actively involved and reporting to state the objective being reached, so that we have comprehensive report of the Republic of Belarus. In 2020 it was published the report of the Russian Federation. Our chair, our department was actively involved in preparing the parts and elements of this report. Both reports, this or that way, touch regional achievements of the MDGs and SDGs, and so they would like to touch on the importance of the EAEU as the locomotive of the regional development SDG. First of all, here I would like to note that EAEU became the first integration achievement that submitted the report to the EU on achievement of the SDGs in the region. It's important because it was submitted as back as 2017, literally 2 years after the agenda in the sphere of sustainable development was adopted. By the way, EU, as comparison, submitted this independent report in December 2019. No doubt, each member state takes specific steps aimed at achieving the SDGs based on its national programmatic documents, strategies, concepts of development, and so forth. Well, economic integration within the framework of the Union is a fundamental additional factor that is promoting achievement of SDGs by the member states. It is necessary to speak about the statutory document. One of the important fundamental objectives of the EAEU, according to Article 4 of the agreement, is creation of conditions for stable development of economies of the member states in order to improvement of living standards of their multifaceted modernization, cooperation and enhancement of competitiveness of national economies in the sphere of global economy, or in conditions of global economy. One has every reason to say that it fully coincides with major objectives in the sphere of sustainable development goals, as we may not deny the fact that all 70 objectives, to greater or lesser extent, they all directly related and are connected with economic development of each particular state in the region, and so on. In particular, support to economic growth, energy security, introduction of innovation decisions in production and consumption, industrial cooperation, transport infrastructure modernization, social and medical services assistance are coinciding with international objectives in the sphere of sustainable development. In order to achieve this kind of objectives within the framework of EAEU, there is internal market of the member states, as well as coordinated and clear policies are implemented that we may look at and evidence about the achievement of these in key spheres of economy. In particular, cooperation of the member states in the regulation of labor migration ensures effective redistribution of labor potential, reduction of unemployment, and ensuring decent labor conditions for citizens. Integration, liberalization of market stimulates development of entrepreneurship, ensures increase of population to wide spectrum of services, which is also development of the healthy competition. One of the key issues of cooperation between the member states is the energy market. Is very important role is played for the Sustainable Development Goals. Shortly, in a nutshell, I would say about major achievements of international processes that are directly related with achievement of Sustainable Development Goals. So I would specifically voice the aspects of cooperation and the Union itself and what kind of Sustainable Development Goals they are correlated with. Well, completion of the common market of medications of the EAEU was completed. The objective was to improve health status of the population of member states, ensuring guarantees of safety of such important goods for development, which is related to Sustainable Development Goal 3. In 2019, in May, a protocol on introducing changes and amendments on the EAEU and the sphere of development of general or common energy market. By 2025, we expect common markets of gas, oil and petroleum products, which is SDG 7. Within the framework of EAEU, we implement common agricultural policy. Here, no doubt, we need to speak about two SDGs, which is fighting hunger and poverty. Cooperation is going on in the sphere of production, which is correlated to SDG 8 and 9. Special platforms are set in order to implement innovative products, high technology products. Within the framework of the EAEU, we also carry out technical regulation of safety of products. We may speak about great deal of number, say, the 1, 2, 3, and number 15 SDGs. We also implement coordinated transport policies, which is SDG 9 and 11 accordingly. In the future, we plan to set up common financial market and ensure freedom of movement of capital. Also, we speak about SDGs 1, 8, and 9 and 10. Well, I would come back to this, which is digital agenda of the EAEU until 2025. Implementation of digital agenda would ensure digital sovereignty of the Union and members, which is mentioned a lot of times, very frequently, both in Europe and in our countries, in China. Very often this issue is raised. As well, in 2015, we have approved major directions of economic development of the Union until 2030. On an annual basis, they adopt guidelines of macroeconomic policy. Macroeconomic stability and sustainable development is very important in order to achieve SDGs 1 and 8, part and parcel. I'm not going to repeat that we have strategic development of European economic integration until 2025 exist. I will proceed from the most important provisions that are publicly available, that we can access. It is necessary to mention about the common market, labor market. I've touched it a little bit. We may refer to SDGs 1, 8, and 9, and 10. We need to remember about support of development and least developed countries from the EAEU. This kind of support is offered through tariff preferences provided to the states according to the Article 36 on the EAEU. So this information can be referred to in the report of 2017. So that's achievements of the SDGs implementation. So, but we need to mention it's not the only document that is developed by the EAEU. We need to praise the activities of the Commission, which is in charge of the 4 directions: implementation into the regulatory mechanism, monitoring of achievement of the SDGs, impact of integration on achievement of the SDGs by the member states, development of new spheres and technologies that would promote achieving the SDGs. In 2019, the Commission has published statistical guidelines on achievement of SDGs, that is, updated the statistics on 2018. So they have shown indicators achieved by certain member states and compared the member states' achievements, which is very important, I would like to underline. One may refer to small mathematics and figures. Experts analyzing this guidelines and this collective works book, in 82% of cases, the EAEU is capable of impacting achievement of SDGs by the appropriate member states. By specific SDGs, regulatory framework documents of the Union fully compliant with the objectives. We speak about Objective 7, which is inexpensive and clean energy, SDG 9, industrialization, innovation and infrastructure, SDG 8, decent work and economic growth, and SDG 16, peace, justice and efficient institutions. One of the most important elements of the strategy of 2025 is digitization of economy, or economies of the member states. We need to remember that the integration spheres existence are receiving new development, impetus for development. However, digital agenda that I have already touched, and I would mention this in a more detailed manner, it is envisaged that attention would be strengthened, aimed at improvement of mobility, decision of social problems, healthcare, and inclusive nature. Digital technologies is one of the most important factors aimed at developing common economic space, creation of common infrastructure based on network principles that would eliminate mediators and extra obstacles as well as other limitations. Strategic directions of activities are focused at development of the digital space and expansion of digital infrastructure. One more vector of development is further development of network of trade relations of the Union with third countries, because we would be faced in the future with enhancement of protective measures. Then the question arises whether the digitization and the strategy of development and the SDGs. The answer is very simple: yes, they are related. Suffice it to take a look at the UN. The Secretary General a number of times have expressed the idea that modern technologies and digitization of economies is one of the most important mechanisms in activities aimed at achieving the SDGs. One more important element of development of digital infrastructure would be attracting investments into the region, which is additional benefit and additional opportunity to develop integration processes. It is necessary to ensure implementation of complex of joint activities aimed at the development of digital assets and digitization of goods and services. No doubt, even though activities are underway within the framework of the EAEU and member states, they are dealing with development of digitization. We need to mention activities of the Republic of Belarus, where this process is very actively promoted and is very rapidly developing. We need to mention the problems existent in this sphere, in this field. So, within the Union, the digital business issues, as well as other issues, as in fact, other integration associations experience this kind of problems, so they are related with harmonization of regulatory framework documents. In each country, they have national requirements and regulatory framework documents that are not harmonized fully and completely. So the value-added chain, producer-consumer, they were not subject to harmonization. So that digital changes have not been implemented. Each country is at different stage of digital development. In order to optimize the business, we need to achieve equal opportunity for the participants and stakeholders. I would like to come back to strategic development in this respect. So the Institute of Development, in the perspective, might bring a lot of considerable contribution in this context. Well, in order to not to go far away into digitization, into other aspects, I would come back to major conclusions, summarizing. The activity of EAEU is directly related by the regional achievement of the SDGs. At present, these integration processes have shown considerable growth, consolidation and harmonization in this field of integration processes. One of the key factors of further development and more successful achievement of SDGs, there would be strategic development of strategic directions of development of economic integration until 2025. Based on the information available, these directions are going to strengthen integration processes, including digitization of the economy of the region, which would improve the achievement of indicators to achieve the SDGs. Respected colleagues, thank you very much indeed for your attention. That's all I wanted to say. Thank you, Andrei, for this kind of detailed analysis of strategic directions of development and their relation to SDGs of the UN. Once again, thank you very much indeed. The floor is offered to Mr. Keshkenbaev, Head of Secretariat and member of the Collegium of Ministries on Economy and Financial Policy of the Eurasian Economic Commission. So important aspects of legal regulation in the European integration, so liberalization of services and labor market. No sound, unfortunately. No sound. Probably your mic is not on. Yes, Lima Charlie. Very good afternoon, dear colleagues. I would like to welcome, first of all participants, and would like to express gratitude to the court and organizers of the conference and for the opportunity to take the floor. Once again, would like to underline the importance of this conference, is referring to the importance of the issues being discussed of the Eurasian integration and the challenges to the international justice. As you know, today, all countries are impacted by the COVID-19, so the global economy is subject to stagnation and recession, so reflected in all spheres, including the sphere of services. Decline in trade and services is recognized in all regions of the world. It is also part of the crisis of countries of EAEU is not an exclusion for the first 6 months of 2020 compared to the previous year. Considerably decreased the amount of services and export. In Armenia it's 40% decrease. Considerable decrease. In Belarus it's 9%, Kazakhstan 23%, Kyrgyzstan 22%. Kyrgyzstan 25%. In practice, the governments reflect on the worsening of the situation, so increasing the regulatory impact on business, which is touching negatively the sphere of services. Liberalization of services is aimed at increasing the level of mutual trade, and is also promoting the development of national economy. So the agreement on EAEU is putting foundation on the provisions of the agreement of 2015, which is aimed at non-compliance, prevention of non-compliance of the provisions approved. Secondly, stability and prohibition of the worsening of the regime of trade offered by the member states to the member states. That is applicable for the date of signing, say 29th of May 2014. So these bodies certified the interests and of the Article 7 of the agreement, so that they taking any measures that are not appropriate should not take place in case this contradicts to the law, to the agreement. The right of simplification and elimination of the excessive internal regulation. That is related to elimination of the barriers, obstacles and exemptions that are constantly discussed as this kind of fora. Within the framework of EAEU, we also have other tools so that we have no limitations, exemptions, or other additional requirements to access to the market of the member states. Automatically recognized and supply of service should be executed without any approval of the powers of legal entity to offer such services. It is related to a considerable number of difficulties. The level of protection of market and labor market, services market, goods market, but it's higher for the level of market of services compared to the level of market of goods. If we speak about the report and the global World Bank, it is established that in the region this considerable level of elimination is needed. Improvement of quality and the range of the services and the elimination of barriers within the framework of specific sector would improve the nomenclature of services offered. According to evaluation of the World Trade Organization, the global services occupy 50%, which is a considerable amount. In course of the implementation of the services market, for the consumer is the result of application of uncertainty and shortage of mutual trust or insufficient mutual trust. Practically speaking, EAEU is faced with a problem which is a stop factor for further implementation of the development of market of services, and the measures of elimination are aimed at. So no direct reference to services existent in the current regime. So the legislators in one state, in practice, cannot exercise their right as they are unable to supply services at the territory of other states according to the rules established. So this is taking place because of ignoring majority of the requirement of the right of the Union to recognize the right to supply and offer services at the territory of other states. Limitation of freedom of establishing without setting up a legal entity, opening a representation office, or sometimes application the banned by the law of the Union limitations. As I mentioned, at the market of services development, which started its activity in 2015, and decision of the higher Supreme Economic Court based on these proposals, 53 sectors of services are transferred, so 55% of all services rendered in the Union. This kind of construction in the sphere of application of law have shown certain difficulties ensuring the implementation in full extent. Article 6 on the agree, so the Supreme Council decision has acted according to the national legislation requirements. At the same time, this kind of procedure as analysis have conducted in according to the current time, so have not taken any acts and actions in this respect. A number of times this issue was subject to discussion at the important fora, so the appropriate representatives have not agreed to ensure compulsory nature of implementation at the territory of the Union, so that's 23rd December 2014, or, for example, in case of the plan of liberalization of certain, so there also emerge additional limitations related to additional burden. Or one more example, establishing and charging direct to indirect taxes that are subject to exemptions or limitations. So we need to pay attention to this problem because different range of obligations and including terminological differences, absence of national regime into the national in relation to taxation of the supply of services and personnel, as well as absence of the opportunity to reconsider it. So these countries independently execute tax policy in the sphere of services, and then 4 types in practice are available, so they have to pay taxes in 1 or 2 jurisdictions, on numerous jurisdictions. As an opportunity to look in the future, we need to speak about temporary nature of the obstacles. First of all, compliance with obligations assumed by the members aimed at not worsening or aggravating conditions of activity of entrepreneurs, revealing and scoping the problems that have been encountered, and then format of common market, and then problems existent. As well, we need to note that major directions of development of the market of services have found itself in the provisions of strategic directions of development. In this respect, liberalization of services would ensure expansion of the trade turnover, improvement of quality of services that are needed, which are especially important in the times of pandemic that our countries are suffering from. And it's especially important because of the decrease of the range of services used and offered within all countries of the Union. Statistical data are proving this. In the future, the market of services needs further impetus, would ensure increase of budgetary supply, or say supplied revenues to the budget. In my presentation, I also have to touch the topic of the labor market within the framework of the EAEU. So the grounds that are laid in the treaty itself, they say that citizens of the Union have preferences. So the countries have assumed the liabilities not to close their labor market, to prevent movement between the markets. The level of preferences, according to the agreement, is practically equaled workers in the sphere of labor. Considerable number of preferences relate to their social security. As you know, Eurasian Economic Commission, jointly with national bodies of the parties, have developed and signed at the highest level the agreement on pensions that envisage equal rights to receive pensions by the country's member states. So the entitlement to pensions. So that's take into account the seniority stage achieved, and the export of businesses from one state to another. They have regulated issues of medical services offered to citizens. The agreement have proven the provisions that ensures pensions. So the practical nature of this agreement, so there's developed a mechanism of transboundary nature for the parties that would be implemented using the integration and information system of the Union. At present, this agreement is subject to ratification procedure in 4 countries that have passed. So we expect in the nearest procedure in the Republic of Kazakhstan, we presume that this agreement would be signed this year. And would undergo the process of ratification and would come into effect. This would ensure and further social protection and implementation of one of the objectives, that is free movement of labor resources within the Union. So, and appropriately further development of integration processes in the Eurasian Economic State. In conclusion, I would like to note that our regional economic interaction is becoming an most important factor of cooperation between the countries. Ensuring using the wide range of the integration instruments is the impetus to improve economic growth of the member states of the EAEU. No doubt that we have well-saturated and comprehensive agenda. Competent and professional speakers would promote exchange of opinions aimed at joint decisions and solutions in order to resolve problems and differences existing in the EAEU. Wish success, fruitful work, fruitful discussion. Would be pleased to take part in the questions and answer sessions. Thank you for your presentation. If any questions would be received, we will definitely voice and refer it to you. So the floor is given to Vladimir Lopatin, Doctor of Legal Sciences, distinguished specialist in the Russian Federation, market of intellectual property, as a strategic priority to EAEU 2025. So Vladimir, the floor is yours.
Good afternoon, dear colleagues, dear participants, dear Mr. Bayashев. My topic is probably the only one declared with respect to the searching for strategic development resources, strategic competitiveness, resting on intellectual property. I will talk about these briefly. So, merging within the framework of the 3 decades-long integration processes, 5 years ago, we made it an objective that the competitive edge of every stakeholder, every member state, would be shared and would be common for the entire bloc. Because only through integration, through piling our efforts together, we'll be able to prevail in the global competitive environment in the light of digitization. So, if we were to look at the risks today, the risks related to digital economy in our countries, for all the 3 levels of digital economy, platforms and technologies where these are created, unfortunately the risks are high. The main risk is the lack of intellectual property in pricing and added value creation. It is happening across the world, where the risk with the market of goods and services is developing within the integration, but with too high added value. High level of incompetence in legal and economic respect on intellectual property in the management also causes our international competitors to go against us. We're basically arming them to fight us. The comparison that we've made, the digitalization decade will be comparable to the electrification of Russia, 1920, 1930. Unfortunately, we're too far from getting there. What do we need in this respect? Of course, if we follow the pattern of the global development in the IP domain, if we consider the risks emerging in the countries of the Eurasian Economic Union, well, these are 2 big differences. The innovative development must go hand in hand with the development of the IP market. Otherwise, it will only be the imitation of development. The UN have recommended the development of intellectual property linked to every level of the society's activity. In Belarus, there is, and Kyrgyzstan are 2 only countries. Belarus is drafting its 2021-2030 strategy, and in Kyrgyzstan, as of 2018, the state initiative to develop intellectual property and innovation have been in place. The EAEU treaty on creating the single markets by 2025 lacks the provision on on the market of intellectual property. Commercialization, the risks are not part of this paradigm. Let's have a look at another trend, another rule of thumb in the world. The businesses will increase their spending by 60–75%. In our case, the budgeting of these processes is increasing. We were supposed to have 50% of extra budget funding channeled towards R&D and digitization. Now it's as low as 20%. Centralization and specialization of state administrative processes, state administration of processes is improving worldwide. However, in our case, in the Russian Federation particularly, it's the other way around. It's decentralization instead of centralization. And this affects various aspects of IP-related legislation in particular. We have 20 bodies the Rospatent office, Russian Patent Office, is only responsible for 6 out of 20 categories of intellectual properties. There is this myth that intellectual property is all about patents. However, 14 out of 20 categories of intellectual property objects are not governed by the Russian Patent Authority. Let's consider another intellectual trend. The IP share in creating added value is growing. 2018 it was 15%. By 2030 it is estimated that up to 30% of global GDP will be accounted for by the intellectual property. Authors, copyright, adjacent rights, know-how, they do not require registration. However, in our countries, in the EAEU member states, the intellectual property is not involved in pricing. There is a lack of awareness in this domain. There are no sales, only as low as 0.05% in Armenia, and up to 2% of IP is sold in Armenia and Russia respectively. So the range is very low. So premature cessation of patent protection is created, which again helps our competitors use them against us, use our achievements against us. In this respect, there has been a significant change in the markets. Particularly, the design phase was emphasized, where trade secrets are created, maintained in secrecy from everyone. This ensures global competitiveness whenever there is market situation arising, the right market situation arising. Basically, the companies that claimed to have one goal, to be pursuing one goal, are making products to fit the future goals. In our case, unfortunately in Russia, for example, we are proceeding from a very different set of priorities, which again determines very low odds of victory in this space. Let's look at the WEF, World Economic Forum Index, GII, Global Innovation Index, ICT Development Index. Using the ICT in the development, our countries rank differently, whereas we're supposed to arrive at similar rankings, comparable competitiveness over the past over the next years. Applications for patents, publications of patents, we can see that in the past 10 years in ICT, the R&D dropped by 10%, the patent applications have gone down by 30%, the Scopus database publications have decreased by almost 4 times, the added value has been reduced by 8%. So what are the rules that we use, that we apply when assessing our effectiveness or lack thereof? Definitely we need to proceed from economics or the economy behind IP. How much added value is created when the intellectual property is being bought and sold in our countries? The 2025 strategy for the Eurasian Economic Union countries, well, when discussing this, we should consider both positive and negative trends. Russia's 2022 strategy, 4 billion rubles were used, so budget funds were used. However, we're nearing the end of 2020 and out of 45 key indicators, not a single one has been reached. Basically, we are at the level of 2010. Still, there's a 1-decade lag. this causes us to reconsider the attitude towards these indicators which have been imposed on us as main KPIs. Therefore, whenever we're talking about recommendations to EAEU managing bodies, the EEC, we must proceed from the harmonized methodology of assessing intellectual property so that we can arrive at the only possible correct decision including strategic development of this component. Talking about different other priorities, such as legal regulation, unfortunately, the Eurasian Economic Commission is only looking at creating legal safeguards, legal protection of IP, and it failed to create conditions for the market of IP to grow. If we compare the legislation of our 5 member states, they are different in terms of including of exclusive rights to IP objects into the civil turnover. We cannot build a harmonized market on different rules. So this should be taken into account by the Eurasian Economic Commission. Proceeding from our mission, proceeding from the pathway, from the algorithm that has been recorded and proved tried and true by the Eurasian Economic Union, the amendments into the EAEU Treaty must be passed to expand the scope of RNEs, to help shape the economy and the market of intellectual property. We should abandon the previously adopted KPIs on patent and patent applications and publications. We need to remove the barriers in this domain, although this is yet to be done. We need to commercialize, and we need to work towards commercialization of intellectual property in our countries. We must use 5 primary models where intellectual property is not just a patent hanging on the office wall. It's also supposed to be an asset, an added value, boosting competitiveness of all the stakeholders. We have the experience of IP commercialization ranging all the way from private companies to inter-regional entities. We suggest that innovative development agenda of our countries should feature commercialization of intellectual property. Otherwise, we'll be simply lagging behind and standing still virtually, as it used to be until this day, as it has been the case until now. We need to involve soft force, soft regulation in this. For example, in China and the US, this is the priority of state policy. Intellectual property standardization is the soft force regulation. The triad, the Intergovernmental Council of the CIS, where there are powers but no means. The EEC has the means but no powers. In the Union State, there are powers and funds, but there are no standards. We need to create a joint task force to avoid these bottlenecks, to arrive at the reasonable decision. Completing my presentation, I would like to highlight that this set of 20 state standards that have been developed by our faculty, we need to regulate them through state standards, intergovernmental standards. This needs to be supported and understood. For example, the Belarusian standard, thanks to the law on legislative acts, this is now part of legislation framework. Also, Russia has this soft opportunity to include normative references to specific standards. However, these are isolated cases that need to be harmonized and used broadly, used in the common way by the EAEU Member-States. So I hope that the matters of intellectual property, inclusion of having them featured in the 2025 development agenda, R&D improvement, scientific potential improvement, these should be standardized, which will yield that competitiveness that we have declared to want to achieve 5 years ago. Thank you, Vladimir. Yes, indeed, the issues that you've raised are quite relevant. Intellectual property has always required special consideration and special attitude. Without promoting these, we will not get anywhere. We will not reach the goals in mind that we had in mind. Dear attendees, the pre-lunch statements have been made. Now we're announcing 1 hour break. Let's be back here at 3 p.m. Minsk time. The plenary session entitled Court of the EAEU and Courts of the Member-States will be announced. Plenary session number 2. Thank you. Lunch break is announced until 3 p.m.
Не слышно.
Слышно, не слышно? Слышно, нет? Меня слышно?
Все, нет, все будет хорошо.
Все, давайте. Давайте подключаем, я не вижу. Так, приветствую всех участников конференции.
I would like to welcome the attendees of the conference again. Let us resume our activities. The second part of the plenary session is dedicated to the topic listed, Court of the EAEU and the courts of the Member States. Aybek Davletov now has the floor. He is the judge of the Supreme Court of the Kyrgyz Republic. He will be talking about the interaction between the Supreme Courts of EAEU Member-States. The floor is yours. Please, the floor is yours. Mr. Davletov, the floor is yours. Please go ahead. Your microphone seems to be muted. We have the visual but not the audio.
Айбек Абубакирович, пожалуйста, говорите, выступайте.
Mr. Davletov, please go ahead.
Пожалуйста, говорите. Так, посмотрите, с ним свяжитесь.
This is a request to the technicians, please
Пожалуйста,
get
мы
in
вас
touch with
слушаем,
Mr.
Давлетов.
Davletov. His microphone seems to be
У вас
muted.
микрофон не работает. Включите, пожалуйста, микрофон свой.
Your microphone
Вас не
is
слышно.
muted.
Вас
We
не
we
слышно.
cannot hear you.
Микрофон.
It is still barely audible.
Пожалуйста, пожалуйста, говорите.
Please proceed.
Его слышно, я не слышу.
The lips are moving, but not sound is coming through.
Так тогда, может быть, следующего ты. В чем дело там?
Some technical issues.
Давайте тогда предоставим слово следующему выступающему.
Okay, I say we give the floor to the next speaker.
Сделайте тогда технически,
Okay,
что там необходимо.
let us get the sound through.
Слово для выступления предоставляется судье Суда Евразийского экономического
The floor is now
союза.
given to the judge of the court of the EAEU, Mr. Chaika.
Тема его выступления
His
роль основных
presentation
прав
will be
человека при
dedicated
толковании права Евразийского
to the
экономического
role
союза. Пожалуйста,
of basic human rights when interpreting the law of the EAEU. Thank you very much, dear Mr. Baishov, dear attendees of the conference. With respect to the previously voiced opinions, previously voiced by the speakers, I mean,
развития и
I
становления
would like to
евразийской
point out
интеграции
that the matter
должен
of
основываться не
formation
только на
of the Eurasian
экономических
integration should not be
проблемах или
based solely
экономическом
on
секторе,
economic
но в том числе
matters,
и на
economic sector.
втором
It should
столбе,
also
о
be
котором говорит наш договор,
resting
особенно в
on the
его
second pillar
преамбуле,
that
это
our
вопрос
treaty
о
deals with,
защите основных
especially the
прав и
preamble.
свобод человека.
This is the protection of
Этой
basic human
теме
rights
как
and
раз я
freedoms.
и посвящу свое
This is the
выступление.
topic I would like to
Практика
dedicate
судов
my
интеграционных
presentation
объединений
to.
демонстрирует, что помимо
The practice
традиционных
of
методов
courts
толкования
of
известных международного
integration
права
associations
и
demonstrates that in
основам
addition to
Венской
traditional
конвенции
methods
о праве
of
международных
interpretation
договоров,
known to
они
international
вырабатывают
law
собственные
and based on the
подходы к
Vienna
внедрению
Convention of the law,
правовых норм.
on
На
Convention on the
определенном
law of
этапе
international
развития
treaties,
национального
they develop their own
образования
approaches to understanding legal
определяющее
norms.
значение
At a certain
приобретает
stage in the
его
development
способность,
of supranational
что не
education,
менее важно,
its ability
готовность
and,
взять на
no
себя
less
функцию
importantly,
защиты
its
основных
readiness
прав
to take on the
человека.
function of protecting fundamental human
Реализация
rights
данной задачи
becomes
приобретает
decisive.
форму
The implementation of this task takes the form of an interpretation of integration law, taking into account human rights posed by our contemporary reality. The significance of this interpretation manifests itself in two ways. The way I see it. First of all, this is the substantiation of the position on the direct action and supremacy of integration law, as well as on the limitation of the sovereign powers of the member states in the domains, regulation of which has been transferred to the supranational level. It creates a situation in which supranational law directly affects individuals, but unfortunately fails to contain any norms capable of protecting the fundamental rights of these persons. The need to resolve a similar issue faced the Court of Justice of the European Union in the late 1960s, and it led to the development of a position on the protection of human rights and fundamental freedoms as overarching principles of the European Union's law. The justification of the court the justification by the Court of the Eurasian Economic Union of the properties of supremacy, direct action, and direct application of its law, in advisory opinions on cases on vertical agreements on professional athletes, on staff cuts, in the decision on the Kaliningrad transit case, the conclusion that the creation of the Union led to the transfer of some of the national powers to the supranational level, in the advisory opinion on pension case, all this goes to raise the question of the next step, which is to formulate a position on the protection of human rights. Secondly, no less important is the fact that the activities of supranational judicial bodies, which seem to be located between universal international courts and the judicial bodies of the member states, lead to an overlap of their practice and sometimes to competition of approaches. as it is justly pointed out by Mr. Ispalinov, it causes the desire to reserve the protection of one or another domain of public relations. The implementation of norms of control by the courts of integration associations, which coincides by nature with the activities of national constitutional courts, the penetration of supranational law into the legal systems of the member states entails the intersection of the competences of courts of various levels. For the courts of member states, especially the constitutional and supreme courts, it becomes fundamentally important to ensure the protection of human rights and fundamental freedoms guaranteed by national constitutions from violations in connection with the operation and enforcement of integrational law. The development of events can be either a conflict between a supranational court and domestic courts, or an interjudicial dialogue. It is no secret to anyone that a similar page existed in the relationship between the EU court and the constitutional justice bodies of its member states. As mentioned in the previous talk by Mr. Galperin, Deputy Justice Minister of the Russian Federation. The consistent protection of human rights by the EU court, primarily in their economic aspect, led not only to the development of legal constructs that enriched integration law, but also the establishment of fruitful interaction with the constitutional courts of the member states. A review of the perception of the standpoints of the EAEU court by the constitutional and higher courts of the member states demonstrates that in the Eurasian legal space, over time, the question of the competition between the competences of the Union Court and the constitutional justice bodies of the member states will also arise. I'm convinced that interjudicial dialogue can only emerge on the basis of a stable foundation, which serve as common values, among which human rights and fundamental freedoms are paramount. For our integration project, it is also of great importance that, unlike the European Union, all of whose members have signed the European Convention on the Protection of Human Rights and Fundamental Freedoms, only 2 EAEU member states are parties to this international treaty. Considering that the transfer by the member states of the Integration Association of a part of their powers to the supranational level does not relieve them from their obligations to comply with the Convention, nothing prevents the ECHR from exercising its competence to consider cases against Armenia and Russia in connection with their violation of basic human rights and fundamental freedoms caused by the enforcement of union rights at the national level. In such circumstances, the role of the EAEU court in interpreting union law, taking into account the provision of human rights, increases many times over. The protection of human rights by a supranational entity, it was pointed out that the Court of Justice of the European Union, in its rulings about the Kaliningrad transit and the vertical agreements, the Court of the Eurasian Economic Union is in a more advantageous position than the EU Court. The protection of human rights by supranational entities through the interpretation of its legal norms is ensured through the perception of the relevant provisions from international law treaties and from national constitutions. This is precisely the path taken by the EU Court of Justice when formulating legal positions in the case of Internazionale, however, and a number of others. Over the time frame mentioned, the economic categories were displaced. It was the Court of Justice of the European Union was limited to the basic values of the right to life, in respect of private and family life, etc. The practice of international human rights bodies was in the process of formation. The constitutions of the EAEU member states include the protection of the right to private property, which is different from the 1960s and 1970s. Particularly the mentioned private property, the right to court, the inadmissibility of double responsibility for one act The preamble to the Treaty on the EAEU establishes a commitment to the unconditional observance of the principle of the supremacy of constitutional rights and freedoms of persons and citizens. This rule became the starting point for the Court of Justice of the Union for using the constitutional traditions of the Member States when interpreting integration law. For the first time, the analysis of the Constitution and the reference to the Declaration of the Human Rights is connected in my minority report in 2018. The proportionality of sanctions in case the EAEU law is broken. Several months on, the Court of the Union went to this norm of the treaty as a prerequisite to provide human rights on the pensions case. It cited that because of in connection with the commitment enshrined in the preamble to the treaty to unconditional observance of the principle of the supremacy of constitutional human and civil rights and freedoms, the level of such rights and freedoms guaranteed by the Union cannot be lower than that provided in the Member States. The application of this approach not only allowed the Court to formulate a legal position on the protection of the social right of employees of EAEU to assign a seniority pension, but more importantly, it has become a universal rule that can be applied when resolving any category of cases. Looking at the practice of the Supreme Court of Russia shows that the position on the standards for the protection of human rights and fundamental freedoms was reflected in its definition of June 17, 2020. In this act, the Supreme Court, assessing the legality of giving retroactive action to the new version of the EEC decision on the classification of a certain type of products, referring and directly citing the advisory opinion on the pensions case, established the inadmissibility of applying the norm of the Commission's decision adopted after the economic entity took a legally significant action. In essence, the Supreme Court has demonstrated its adherence to the principle of inadmissibility of retrospective application of the provisions of the Union law that worsen the rights of individuals, and remarkably did so with reference to the advisory opinion of the Union Court. This example, the way I see it, serves as a manifestation of an effective dialogue between the Integration Court and the Supreme Court of a member state, which obviously leads not only to the formation of progressive legal constructs, but also to the protection of the rights of individuals. It is noteworthy that in the future, the standpoint of the Union Court on the protection of human rights at a level not lower than in the member states was used by the Court of Cassation, the Arbitration Court of the Northwestern District, in the ruling dated July 13, 2020. Returning to the jurisprudence of the Court of the Union, I know that the interpretation on the basis of human rights was further developed in the advisory opinion on the non bis in idem principle case. The EAEU Court formulating the rule on the impossibility, and the sound is gone. It referred to subparagraph 1 of paragraph 50 of the statute, by virtue of which, in administering justice, the court applies generally recognized principles and norms of international law, and then pointed out that when judgment was delivered, it was based on the general constitutional traditions of the member states and international agreements on the protection of human rights. At the same time, the advisory opinion does not contain references to either specific norms of national constitutions or relevant international treaties. You can more fully understand the position of the Union Court through appeal to the dissenting opinion of a minority report of Judge Seitimova, in which it is indicated that the corresponding principle is enshrined in the International Covenant on Civil and Political Rights, Protocol number 7 to the European Convention on Human Rights, and is also guaranteed by the constitutions of the member states and acts in criminal law legislation as well as legislation on administrative offenses. Concluding my talk, I would like to note the following. The appeal to fundamental human rights when interpreting the law of the Eurasian Economic Union can not only contribute to the effective protection of the relevant rights and build a dialogue with the courts of the member states, but also become a stage on the way to the formation of a catalogue of human rights within the EAEU, the development of which, in my opinion, is just a matter of time. Thank you for your attention. Thank you, Konstantin. The matters of provision of human rights and the citizens' rights are studied by you for a long time. It is implemented into practice of the EAEU Court. It deserves the opinion both theoretically, from the viewpoint of theoretic substantiation of this problem, as well as the practical implementation. A 5-minute break is requested by our tech staff to get in touch with the following the following panelists. Thank you.
Отвечай.
Эй, эй, эй. 1, 2, 3. Раз, два, три. Так. Коллеги, выходим.
In a matter of seconds.
Приносим свои извинения.
We apologize for this technical glitch.
Слово для выступления
The floor
предоставляется
is given to the judge of the Supreme Court of the Kyrgyz Republic,
Айбек Абубакировичу.
Mr.
Тема его
Avlet
выступления
Davletov.
взаимодействие верховных судов
His
членов Евразийского
topic,
экономического
as declared,
союза.
is the interaction of the courts of the Eurasian Economic Union. So, thank you. Dear colleagues, please allow me to welcome you and wish you a successful event. My presentation, because of the time limit, because of the constraints of time, I was given short notice to prepare this, will be more of a replica than a full-fledged presentation. I've been asked to come forward with suggestions on the improvement of cooperation. I believe that the activity of the Union Court is important, particularly in the development of uniformity in law enforcement, of legislation underpinning the operation of the EAEU. For example, the question of the forms of interaction between the Court of the Union and the national supreme courts of the countries included in this union is relevant. On top of that, I wish to emphasize the importance of the Court in supporting economic and overall relations between our countries and peoples. This scientific and practical conference is of particular positive charge for its attendees and myself in particular, because I would like to give my best to Ms. Sietimova, Mr. Kashkembaev. I've used to be working with them as a member of the plenum of the court of the CIS. Mr. Jibraimova, I would also like to give my best regards to you. Regarding the stated topic, the interaction of the EAEU court and the national courts of the EU member-states, EAEU member-states, I'd like to dwell on some issues that, in our opinion, are important both for the EAEU court and for national courts in terms of mutual influence on the development of uniformity in law enforcement. For example, the matter of the forms of interaction between the Court of the Union and the National Supreme Court of the countries included in this union, as mentioned, is very relevant. In accordance with the provisions of the Statute of the Court, its powers include ensuring the uniform application by the Member States and bodies of the Union on the treaty, international treaties within the Union, international treaties of the Union with a third party, and decisions of the Union bodies. Could there be any cooperation here? This question is being asked because there is no trace of this collaboration, unfortunately. Perhaps it is there at the level of the management, of the leaders, but ordinary rank-and-file judges fail to quite observe it. While ensuring the uniform application by the member states and bodies of the Union of the treaty, international treaties within the Union implies, obviously, first and foremost, coordinated activity in this domain of national courts. The appropriateness of this point is confirmed by the published decisions of the Court of the Union and their significance for the consideration of specific cases of customs disputes in the courts of the Union countries. In this regard, it was with great pleasure that I read the article of the judge of the Union Court by Tatiana Nishataeva. It's written with the highest professional quality. So she wrote the article, "The Effect of Acts of the International Court in National Legal System, exemplified by the acts of the EAEU Court." However, it is very important for judges to understand the norms of union law by the EAEU court, recognized by all national courts and applied by them in resolving a specific dispute. In this regard, the above question is asked: how do we achieve the increase of the efficiency in the union court? In our opinion, there may be several possible ways. Each of them may be controversial or not entirely convenient or correct to use, but through discussion, states can come to a consensus and solve this problem. For example, generalization of the judicial practice of the Union Court could be subject of consideration by the Supreme Courts of the Member States, drawn up in the form of resolutions of the plenary session, binding on local courts. An example is the resolution of the plenum of the Supreme Court of the Russian Federation of 2016 on some issues of the application of customs legislation by the courts. It is also possible to consider the practice of the EAEU court as a new or newly discovered circumstance in the revision of court decisions that have already entered into legal force. For example, the decisions of the courts of the Union Court are binding for the Kyrgyz courts, particularly. We can also apply the practice of the Union Court when considering or reconsidering the legal acts or the legal decisions that entered into force. This way, essentially, it's a good way to look into the problems occurring in the EAEU space. Particularly, the decision of the court created by the international treaty, party to which the Kyrgyzstan Republic is, based on the cases in the Kyrgyzstan Republic. There is also such an opinion as the receipt by local courts of the possibility of sending official requests to the EAEU court on specific issues requiring clarification or interpretation of the norms of an international treaty of the Union. Unfortunately, the Kyrgyz legislation limits such powers by courts. Only if there is legal uncertainty, the courts are free to send a clarification request internally in the Republic. However, the idea of sending official requests to the EAEU court on specific matters should be considered by the legislature. So it would be great to create a plenum of the EAEU court, including a good way to develop a unified approach to the application of the Union's legal norms could be in the creation of a plenum of the EAEU court, which includes the heads of the national courts of the Union countries, following the example of the CIS Economic Court. Having been a member of the plenum of the said court for many years, I had to take part in its activities more than once, which brought only one benefit, and that is when applying the norms of international law when resolving specific disputes in the courts of the Commonwealth. Of course, these proposals may require amendments to the national procedural legislation. However, this can pay off 100-fold and bring far more value to than the cost. Thank you. My presentation is exhausted. Thank you very much. Thank you for your analysis and your proposals. Definitely, the interaction of national courts and the Union Court along the directions that you have mentioned is very much needed and practically relevant. We ourselves have been raising the matter multiple times about prejudicial requests by national courts into the Union Court to receive appropriate clarifications, interpretation of the EAEU law, so that member states' courts can take that legal advice, that advisory opinion, and they could use it to resolve disputes in their respective member states, because the main objective of the court is harmonious enforcement of the legislation of the EAEU, which is impossible without cooperation and interaction of courts operating in each individual member state. So your proposals and your opinions are very important. Now the floor is given to the judge of the Supreme Court of the Russian Federation, Natalia Pavlova.
The topic of representation, the role of law of the EAEU in ensuring protection of fundamental human rights by national courts of the member states. So the floor is yours. Very good afternoon, dear colleagues. Thank you very much indeed for the opportunity to take the floor, and would like to express the words of gratitude and at this uneasy condition, so that you did not abandon the idea to organize this kind of important event. And the tradition that was placed was embodied a number of years ago, continuing, and enables us discussing important issues that are part of the judicial practice and court practice in the current difficult and uneasy conditions. Would like to introduce for your consideration my ideas and suggestions. What is the role of law of the EAEU in ensuring the major fundamental rights for human rights through the prism of the national courts of the member states? First of all, the Russian courts. The modern stage is depicted by quite deep integration of the states. We are all mentioning and noting this. It is exactly this ideology was touched by many presenters and reflected in many statements. So the evaluation of the integration impact on different spheres of our life is studied by different scientists, economists, sociologists, politologists, and certainly the legal science is not standing outside. So the legal science as well is involved in studying this kind of phenomena. As well, the law, which is putting integration process into appropriate recognized form, is the subject of studying by this legal science. On top of this, integration was promoting creation of real specialized form of sphere of law. At present is separated as the Law Institute Integration Law, so the subject of which would be studying integration process from legal point of view. Legal analysis of integration as social phenomena has revealed a new source of legal regulation of public relations. So the acts of integration law, which includes international agreements of the establishing nature and acts that are developing the basic integration norm per se, as well acts of international integration organization. They are referred as the secondary law. Any regulatory framework document has the subject of regulation, the sphere of relations, as the regulatory framework is stipulating the rules of behavior of entities in the sphere of relations. So the entities are reflected in the integration relations are regulated by appropriate sphere. One may ask a question: what are the rules of conduct from the legal point of view out of rights and obligations that are offered to the participants of these relations? Evolution of humankind and legal evaluation of this evolution in the aspects of the opportunities that are offered to the individuals resulted in developing of Institute of Fundamental Human Rights and Freedoms. This is the basis of the legal status of the individual. I wonder whether this basis is changing, whether the subject is functioning in the framework of the integration association, whether it's subject to evolution, modernization, acquires wider or narrower, or whether it keeps this important and its value. In essence, these are the questions whether the integration law brings its own specific feeling of the legal status of the actors and the subjects. Fundamental rights and freedoms, whether they are of no special importance. Within the framework of integration, they offer special rights and guarantees, and it's sufficient for the specific and successful existence of the subject, and other rights are not needed. Would that be appropriate to judge like this? Answer to this question might be done on the basis of analysis of development of legal regulation on the integration associations and legal practice that is ensuring successfulness of this integrational legal regulation. What kind of practice we're talking about? We mentioned this in the course of our previous meetings. The issue of interaction between the supranational and national justice was subject of our discussion that was started, if everyone remembers, in the course of the conference in Suzdal. And then we continued at the fora of the previous conferences that were conducted under the aegis of the Court of Eurasian Economic Union. In the course of discussions, we arrived, in my understanding, to specific conclusion. Real life of integrational law is ensured not only by activity by supranational court bodies, by the judicial practice of the member states. Can we speak about specific subsidiary mechanism in relations between the national justice and supranational judicial body in the model of EAEU? What is recognized in a number of international institutions like the law of the Council of Europe. Or in relation to Eurasian Economic Union, this question requires additional research. Indeed, it requires additional studying, additional research, but the fact that the law of the Eurasian Economic Union became the subject of judicial interpretation and application inter alia, within the framework not only supranational judicial body of the EAEU, but as well courts of the member states, this is the kind of fact of life. In case of the court of the Eurasian Economic Union is the highest body which is assigned with specific competence and responsible for ensuring the common interpretation of the law, what is the role of national courts of the member states to the law of the Eurasian Economic Union, to keep the common feature which is designed and stipulated by the supranational court. What for? In order to ensure efficient protection based on the law of the Eurasian Economic Union of the rights and freedoms of the humans, of the individuals. How does it happen? The law of the Union is an additional instrument based on which protection of rights and freedoms is ensured. Integration union of economic nature, say economic rights and freedom, so right of property, freedom of entrepreneurship, and deeper forms of this freedom expressed in the framework of integration association, freedom of movement of commodities, services, free competition, the right to work, and the integration association, the freedom of movement of labor force. So therefore, integration law ensures respect to major rights and freedoms at the higher, qualitatively deeper level. Since mid-20th century, humankind recognized that fundamental rights and freedoms could be efficiently protected, not only framework within the certain specific states, but within the framework of international associations. This kind of approach would improve unprecedented individual state disrespect of value of human rights that Europe suffered through the 30s, 40s of the 20th century. So this resulted in the creation of the UN and Council of Europe, International Humans of Protection of Human Rights. But supranational mechanism was not the only one, but an additional one. Once again, the law of integrational association is an additional tool of deeper protection of fundamental rights in their specific specialized elements, which is one of the most important values of integration. Say, European Convention on Protection of Human Rights and Freedoms, adopted in 1950, the major instrument of protection of human rights within the Council of Europe, offers member states to protect and reflect in their acts the deeper list of freedoms and rights, improve guarantees. Whether this convention offers something to associations that are not aimed at specific protection of human rights. Yes, definitely. These mechanisms exist together, interact, and then common European mechanism could be expanded due to additional guarantees of integrational association, but could not be leveled down or acts of regulation created on the basis of integration law by the courts of the member states. Vice versa, integration law, which is additional mechanism of ensuring and compliance with human rights and freedoms, provides for its better protection. So therefore, integration of legal mechanism is not simply a combination of bridges that are built to improve interstate relations and solving political issues. Supranational international legal mechanisms, say European Court for Human Rights, and integration specialized economic associations, exactly in their joint application would improve more efficient protection of the disrespected rights of individual subjects. A bright illustration would be judicial practice. Say, in particular, national judicial bodies, say, in the Russian Federation courts, exactly application of integration law through the prism of protection of human rights very often ensured the courts and the Supreme Court of the Russian Federation to find balance into disputed relations and ensure fair resolution of the dispute. One of the important rights, property right. Modern system of protection recognizes as one fundamental. Article 1, Protocol 1 to the European Convention of 1950 describes this right. Integration law of economic associations, due to its economic nature, is aimed at protection of property. Exactly its norms, in combination with fundamental right of humans, of individuals to protect property, find efficient court solution in a specific dispute, as well as element of property right as the right to conduct entrepreneurial activity due to use of its property. This ensured application of the protection of rights of participants of relations that are forced to transport goods and commodities at the territory of Russian Federation that are subject to economic measures and economic limitations in relation to primary economic limitations introduced by third countries into relations of citizens and legal entities of the Russian Federation. However, they have to protect their rights and interests. One was supposed to ensure proportional nature of such measures and their extent of proportion. So they are reflected in the norms of integrational law. Say, Article 3 of the Treaty of the Eurasian Economic Union fixes this kind of fundamental principle as principle of taking into account national interests of parties, which includes ensuring security, economic security in particular of the specific separate member states, as well norms of international integration law, evidence that any measure aimed at protection of such fundamental value as security of specific state, they should be of proportional nature. Inter alia, to ensure freedom of trade. Accordingly, national legislator will have to consider an opportunity to balance ensuring of such interests. In particular case, instrument of ensuring the balance would be an opportunity to market to exercise the right for customs transits of such goods at the territory of Russian Federation by the considered subject of law. On the basis of such comprehensive application of law, courts of the Russian Federation protected rights of individuals who implemented the right to customs transit, cleared through customs, so that the customs authorities were able to make sure that the transit transit nature. The right to consideration in the court is the fundamental right in the sphere of protection of human rights. European Court on Human Rights has developed this the basis of application of the norms of Article 6 of the European Convention. Many approaches of the European Court, as we know, became international standards and received implementation into judicial practice and legislation of the member states. One of these is the concept of legal certainty and reasonable expectations of presence as such. So reasonable expectations may be based not only the legal certainty arising out of norms of positive law, but legal provisions that are determined, fixed, stipulated by the judicial bodies. So the common approach of judicial practice in specific dispute, there has been an issue of protection of rights in course of changing the approaches have taken shape in the judicial practice of the member state on the classification of goods in commodity, in customs interests that was taken by decision by Eurasian Economic Commission. However, the legal practice of the member state saw a different approach, which resulted in approach in specific reasonable expectation of such relations. How this kind of change affect or impacts the human rights or legal entity rights which are based on reasonable expectations generated on the basis of legal certainty arising out of the national court practice. The question was resolved in the act of the Supreme Court of the Russian Federation based on common application of human rights and integration law of the Eurasian Economic Union, primary, secondary act, and the respected court of the Eurasian Economic Union. International agreements that were mentioned includes, of course, the agreement on the Eurasian Economic Union and the customs code of the Eurasian Economic Union. Provisions of such acts determine the classification of certain type of goods which exclude the approaches that were taken previously in relation to this classification. However, these kind of rules were not determined in the provisions of the code. And absence of such provisions, both in decisions of the Commission that have changed the rules of classification, which is decision 156 dated 2017 in relation to such kind of commodity as children's diapers. Whether this is subject to, or whether this covers only simply the fact of declaring the commodity or the commodities that were declared previously. However, in the preamble of the agreement, there's obligation of the member states to unconditional respect and principle of rule of law, constitutional rights and freedoms of the individual and citizens. In interpretation of the court, referred to in the consultative conclusion in December 2018, we could trace the following provision. The preamble of the agreement says that the level of rights and freedoms of individuals and citizens guaranteed by the Union cannot be lower than that is provided by the member states. At the same time, the law of the Union established general ban on application and the reverse application of decisions of the Commission that would be worsening situation and position of natural or legal entities that is applicable to any regulatory framework of the Commission. The appropriate approach resulted in balance and protection of reasonable expectation of entrepreneurs, legal entities. So therefore, they have expanded the law in aspect of reasonable expectations based on legal certainty. So this was respect to human rights and respect to rights of integration association. The respect of privacy, safe environment, safe conditions of existence. Well, it seems to be how this kind of fundamental rights can be touched by the law of integration association. The model of protection of human rights envisaged by the European Convention 1950, this right is guaranteed by the provisions of Article 8, that is ensuring that public authorities should protect national security and health of individuals and other persons. But this is a universal procedure. European Court of Human Rights a number of times noted that the state represented by appropriate authorities is responsible unless the latter fails to take measures aimed at improvement of the environment envisaged both by national legislation as well as international law. It's indicated in the European Court of Human Rights 2005 case Fadeeva against the Russian Federation. How to find balance between economic interest of certain individuals and environmental interest of others. Courts do find very often through combined interpretation of integration law and law of the human rights. So there are commodities that are of enhanced danger both for security of individuals and for society as well. Say, for example, cement. So bringing into any territory in the customs regime should be subject to additional control of safety. That is to exclude the threat to humans' safety and their security. Additional inspection control mechanism is established. So exactly, it's the instrument of balance between economic and ecological rights. Ensuring the safety of commodities that are circulated at the territory of the Union is public or is part of the sphere of public interest. Therefore, relations arising between the declarants and customs authorities that are proved by the declaration and conformity of the imported commodities based on imperative beginning. And it's established by the decision of the court. The volume and procedure of confirmation is established by the law and does not depend on the one who declares. The permission to use internally the commodity brought into the Russian Federation and arising outside of the territory of the Eurasian Economic Union, in relation to which there are specific rules that requires conformity the products to technical requirements in order to ensure its safety without this kind of additional control is not allowed. So in this particular case, integration law became the basis, the foundation of this balance. That is item 1 of Article 53 of the agreement of Eurasian Economic Union. So that stipulates that products permitted in circulation in the territory of the Union should be safe. In development of such provisions in the customs code norms, it is established that commodities transferred to the customs body of the Eurasian Economic Union and are subject to customs procedures, including the customs procedure of issuing permit for internal consumption, in case they comply with bans and limitations, which are understood as the technical regulation measures applicable to the commodities being transferred. In relation to cement, that is arising outside of the territory of the Eurasian Economic Union, such specific rules are applicable that should confirm conformity to the technical requirements, because this kind of confirmation is compulsory as excluding risk of introducing the dangerous commodity that might negatively impact the environment, human health, public and state property. Again, we see that this is reflects on balance of rights and interests of participants of relations, complex of relations, which is achieved to comprehensive application of the integration law and protection of fundamental rights. These are examples of interaction between the law of human rights, integration law, in the practice of the Supreme Court of the Russian Federation that have taken shape in the recent time and that are evidently confirming the thesis of importance of the presence of both legal instruments and protection of human rights. And not only importance of existence of such, but its efficiency. Thank you very much indeed, dear colleagues, for your attention. And I would like to wish you all in the kind of to stay healthy, and would like to wish you new success irrespective of any circumstances.
Thank you, Natalia. Thank you for your interesting talk, as always. The matters of interaction of national economic interests and the link thereof to fundamental human and citizens' rights is definitely of high interest to us. And you have vividly shown its interrelation, dialectic interrelation, their intertwined nature, and the protection of fundamental human rights based on mutual support, mutual tools of support, the tools augmenting each other. I would also like to wish you success in the matter of standing up for citizens' rights, as well as at the level of international blocs and unions. The floor to speak is now
руководителю практики таможенного права
given
и внешней торговли
to the head of practice of international law,
Чикину Владимиру Ивановичу.
partner Vladimir
Тема его
Chikin,
выступления классификации товаров,
BCLP Russia.
практики суда ЕАЭС и судах Российской Федерации.
He'll be talking about the practice, or law enforcement practices, classification of goods in the practice of the court. Dear colleagues, thank you very much for the opportunity to speak at this forum and voice my private opinion as to the practice of classification of goods and the practice of the court of the EAEU, as well as the practice of classifying the same goods nationally in member countries. So I'm talking about the situation when the decision taken at national levels, customs decisions, have been successfully contested in the courts of the Russian Federation, after which there was a situation emerging because the Federal Customs Service adopted a decision to classify them at the level of the Eurasian Economic Commission, and it acted in the interests of the relevant taxation authority, the customs authority, and this decision was further appealed. Me as a practicing lawyer, as a practicing defense attorney, there is this opinion shaped, there is this perception shaped among the market players that the European Union Court always defends the standpoint of the customs authorities in each member state. So is this true or not? This is first and foremost addressed to the market. Well, this viewpoint is wrong. The way I see it, they got it wrong. The court does not always, regardless of the circumstances of the case, does not always support the position of the state. Otherwise, there'd be no justice whatsoever. We would not have the luxury to expect our legal rights and interests protected. I have prepared a small presentation. I'll share the screen now.
В этой презентации я буду говорить о том, что
So in my presentation, I will use specific cases, specific legal cases to illustrate.
Владимир Иванович, пока ничего не видно.
Vladimir, we only see your name and the black screen. The slides are not shared. Yes, I understand. Give me a second, just bear with me.
Что-то хотите показать, но мы ничего не видим.
Yes, I just want to share my screen with the slide deck.
Это будет сделано достаточно быстро.
This will be done very quickly. That slide deck is small.
Секундочку.
Just bear with me for a second.
Может быть, вы словесно
Maybe you could
Конечно, я и слове.
ignore the slides. Well, I'll do both. I will.
Ладно. Уважаемые коллеги, извините.
Okay, anyway, dear colleagues, I apologize for this technical issue on my side.
Первое, что я хотел
Включите, пожалуйста, свою видеокамеру.
Your camera, if the slides are not working, we should at least see your camera. Okay, first and foremost, I would like to state this. Is the statement true that the Federal Customs Service of Russia, having lost the cases on classification of goods in Russia, it initiates the adoption of classification decision by the Eurasian Economic Commission? Out of 6 cases considered by the EAEU court, only 6 have been considered at this level of the Eurasian Economic Union. Out of 7, only 6 have been considered by the EEC. We have the ONP LLC, then there was a shipping engine, vessel's engine, classification of syringes, so syringe pens, injection pens, and 2 cases that were dropped because of some fundamental reasons. The ONP LLC mentioned won the case against the Belgorod city customs. The dispute was this: what is the particular vehicle? How is it classified? Is it a tractor, or is it an off-road vehicle? Essentially, a tractor prime mover, multi-purpose armored tractor. So ultimately, the Belgorod Customs lost this case, which it further contested in the EEC court. The case was won by the case was won. Another case, Sanofi Aventis East. It created a dispute against the Kursk Customs Office about disposable injection pens. They won the case. They went all the way to the Supreme Court. The Supreme Court ruled that the previous decisions of the lower instance courts were justified and legal. Then the Kursk Customs Office pushed the case to the EEC court, and in this case, Sanofi Aventis lost this case. The statistics says that it is wrong to say that some cases were not considered at the level of the national legislation. However, the decisions were still made, the legal decisions were made. The statistics shows that having lost well, basically, the statement that I put forward earlier, it is wrong to say that the Federal Customs Service of Russia elevates the cases to the level of the EEC court, having lost them nationally, and wins it. We will consider this, these decisions in the context of their adoption, of them being passed. Yes, indeed, the Federal Customs Service abuses its right to initiate the decision-making at the level of the EEC. Right. In this relation, or with respect thereto, the market has a question. Why go to court involving something big with the customs authorities of Russia, when sooner or later the Federal Customs Service will elevate the case to the Eurasian Economic Union Court, and this decision will not be over. There is no to overturn this decision. If the courts, if this court, Union Court, always defends the side of the state bodies. There is a second statement. Is it true that the court always takes the side of the EEC in the classification disputes? So there was a total of 6 disputes on the matter of classification of goods in 2 instances. 2 instances, once again, in the Union Court, the court of the EAEU. The first case about those prime movers, about the multi-purpose prime movers, towers. The court defended the position of the LLC, of ONP LLC. Second decision, General Freight, closed joint stock company. The decision was passed in favor of the EEC. The next decision, the ship trade, the vessels, engines. It's a pity that this decision was passed as it was. It was the diesel engine that basically causes the vehicle to move forward. So there is a diesel generator that triggers the operation of the engine, the propelling, that's basically the propeller. The ship trade's position was maintained. The EEC changed the initially contested decision, but that change or that amendment to the decision passed was not essential. was immaterial. So just a technicality. So it seems to me, and the market also tends to maintain this standpoint, that the Eurasian Economic Commission, the EEC, is not too subtle, well, I'm choosing my words very carefully here, was not too careful to the decision of the Union Court for this matter. Because ultimately, the claimant did not get anywhere from the outcome of the court proceedings in his favor. Another decision for those disposable injection pens, Sanofi Aventis East, it was won in the Russian Federation, but it was lost in the Union Court. When the EEC court was mentioned explicitly, when this happened, I took a long time to think about what's going on. And it clicked in my head. I realized that the case against the EEC can only be one. The classification cases, classification court proceedings. If, based on the formal logic, the Commission has no possibility to follow the adopted decision. So, having undoubted formal grounds raises the odds of winning a case against the EEC on the clarification matters or classification matters. If we're talking about similarity, or if we're talking about adopting similar decisions, or decision making based on the commonly accepted norms of the law. Me, as a practicing defense attorney, I would never say that the odds are 100%. Yes, the odds are high. However, they are smaller in those cases when these odds of success, odds of victory, are lower. Then compared to cases when there are formal grounds to make a decision, make a specific decision. Also, two decisions were made in favor of the EEC from the claims from Belarusian claimants. So it so happens that the EEC adopts a decision not always favoring state bodies, not always favoring the position of the Commission or customs authorities. So I cannot really say that the statement is true that I put forward earlier, that the EAEU court always takes the side of the EEC in classification disputes. I will make sure this message is passed by me to the market. Thank you very much for your attention, and thank you for the opportunity to speak at this major forum. Thank you, Vladimir, for the position voiced by you. As I've gathered from your presentation, you were one of the sides of the dispute, and you were really getting to the bottom of the cases that you were working on. However, you can see that, or you said it yourself, that the court of the EAEU passed verdicts both favoring the state bodies and not favoring state bodies. So this is just another confirmation to the fact that the EAEU court objectively considers the circumstances of the cases, and even the decisions taken by the majority of voices of the judges are not unanimous. This contributes, or this basically shows the range of opinions in the EAEU, among the EAEU court judges. One more case that I can mention here, yes, I was also part of that, about those artificial gems, artificial corundums that the court ruled not in favor of the EEC. There was another decision by the EEC about fining economic operators because of competition. The Court of Appeal also deemed it not compliant with the international treaties. So definitely saying that the EAEU Court always assumes, always takes the side of the state bodies is definitely wrong. Well, this is exactly what I wanted to show. I have direct relation to the cases you've mentioned. I know this firsthand. And like I said, I will send this message, same as you're voicing now, to the market. Okay, so according to the court verdicts, not always the decisions are made that the economic operators are happy with. Like you said, this decision can be handled, this situation can be handled in a different way. A new decision is passed. And in this case, any decision that contradicts the treaty of the EAEU or any documents governing the EAEU's operation, any norm not compliant with the international law, nobody prevents that infringed economic operator to go to the court, trying to contend the decision if it is not compliant with international law. Like you said, the court of the EAEU's decision is binding on the EEC. The EEC is supposed to correct its decision to match the decision of the EAEU's court. If this does not happen, the economic operator can go to the court, so that the court petitions to the Supreme Council of the 5 heads of state about failure to comply with the court's decision. In this case, the case is elevated to the highest level, which is not desirable to anyone, including the Commission. Thank you very much for your talk. Now I would like to pass the floor to Ekaterina Dmitrikova. She is the adjunct professor, Department of Administrative and Financial Law, St. Petersburg State University. She'll be talking about the influence of the EAEU law on the practice of implementing labor migration legislation. Please, the floor is yours, Ekaterina. Thank you very much, dear Jolombet. Dear colleagues, I would like to thank you for the invitation to participate in this conference. Although I will not conceal this, I come to Minsk every year with big pleasure. However, working online for this first day, I have seen that the quality of the talks does not suffer because of the online format. Very content-rich material as always. I will elaborate on the same topic that my colleagues have started within this panel, namely the application or the enforcement of the EAEU law by national courts. I will also mention the practice of enforcement in the field of labor migration. A labor migrant, in accordance with the International Convention on the Protection of the Rights of All Migrant Workers, is a person or worker who will engage in or have been engaged in paid activities in the state whose citizen that person is not, ergo migrant. With respect to our discussion topic, that citizen is a non-citizen of the specific member state he or she are in, but they are a citizen of the Eurasian Economic Union. In this case, it's very important that the sides have agreed on this unified policy. And Article 2 guarantees the freedom of movement of labor force, of workforce, along with other freedoms. Same as Article 4 of the treaty, it shapes the common market of the workforce. Applying to the declared freedoms, the preamble is particularly relevant in the Treaty of the Eurasian Economic Union. The principle of sovereign equality of the states, which in the context of labor rights is particularly important, compliance with constitutionally guaranteed rights and freedoms of the persons and citizens. Given that the national legislation is maintained when determining the status of foreign workers, and it's particularly important the duties borne by or assumed by the employers I would say that the add-ons to this national legislation exist in the EAEU legislation. Particularly, this is the provision of the preamble I have just cited, and the provision of the treaty on the establishment of EAEU. This is Articles 96 and 97. For law enforcement practices in the domain of labor migration, it's very important that the Article 97 says not just the necessity to obtain the permit, the work permit, but also it's important for the national law enforcement practice. It's important to have citizens of member states involved in any particular member state's labor activities. The Russian Federation defines the status by the federal law on the legal standing, on the legal status of foreign citizens. These norms are regulative. Should this legal provisions be broken, the Code on Administrative Offences lists several grounds to hold the perpetrators accountable administratively, as well as sanctions for the violations by the workers and by the employers. The sanctions are quite severe, penalties and the possibilities for administrative deportation. For employers, these are administrative fines, hundreds of thousands of Russian rubles, pretty severe fines. Getting back to the Article 97 of the treaty, I would like to highlight the following points. Whose duty it is, the employers or the workers, how it's defined in the national legislation. Is there a retroactive force of the law? And if so, how will the court determine the basis for cancellation or for waiving the responsibility? The third part, how does the status of a labor migrant affect the content of other responsibilities? If I may, I will start from the latter point, from the latter aspect. With respect to national law, and I'm talking about the practice of Russian courts, there is a practice of applying the treaty's provisions. Konstantin today mentioned about the retroactive force with respect to the acts which are part of the legal framework of the EAEU. Foreign citizens were found guilty of administrative offenses, particularly the rules of stay in the Russian Federation, whereas Article 98 determines the duration of temporary stay of foreign citizens and their family members. And when it does so, it relates or it links this length of stay to the duration of the work agreement. Getting back to the judicial practice, the first issue that manifested was the issue of applying the law retroactively. So the violation was committed after the agreement or after the treaty was put into force, and the courts faced the question whether this agreement can be found a violation retroactively. The Article 1.7 of the Code on Administrative Offences has been applied in the Russian Federation for a long time. There's been a long-standing history of application. When, for example, there are amendments to the Code of Administrative Offences, or when there are lower fines or lower penalties, the content of the responsibilities changes. Not always have the courts been able to form a uniform approach, because when the violation by a foreign citizen was committed, but the violation preceded the entrance of the treaty, the practice was to favor those foreign citizens who committed these violations. That is true for current situation. If a foreign citizen breaks the length of stay rules in the Russian Federation, referring to the time frame other than the duration of the labor agreement or labor contract, that foreign citizen is supposed to prove the validity of labor relations. In this case, the practice is not so unambiguous. I mean, from the viewpoint of the lack of body of evidence that the court that the court analyzes, considers, and then appoint or then pass a decision either to withhold or appoint administrative punishment. Second category of disputes arising is the duties of the foreign citizens. Again, analyzing the law enforcement practices, we see that the disputes mostly arose out of applying or non-applying of retroactive force of the law. I mean the treaty on the EAEU. I mean, if the violation was committed before the treaty was entered into force. Initially, there was a lot of cases, a substantial amount of cases, when the courts did not withhold the administrative punishment because the violation was committed before the treaty allowed this practice. It is a great thing that this practice became established, and foreign citizens are not sentenced to administrative punishment. Even those decisions that were passed after the statute of limitations, I mean, there was a cessation of the criminal cases were dropped because there was no content, there was no wrongdoing. Otherwise, if only the statute of limitations expired, this would be a non-rehabilitating circumstance. Another point I would like to emphasize is whether the regulation stipulated by the agreement is the right that's only granted to employers or employers and employees alike. Also, there's been a long-standing ambiguous practice where in some cases the courts refer to Article 97, which means the cancellation or revocation of the working permit, and it only affects the rights of the EAEU member-state citizens. Unfortunately, even though Article 97 is quite clear on that, the cases, the courts pass decisions in conflict with it. The employers are still supposed to file evidence that the specific workers were taken on, and this is not to violate the treaty on the EAEU. Over time, the only relevant point here is the application of Article 97, and the enforcement of the provision of Article 97, even in those cases where the violation was committed after the EAEU treaty entered into force. So these are the three typical pitfalls that foreign workers and employers faced, regardless of the fact that, again, Article 97 emphasized the right not only to individuals but also to legal entities, to the clients, to those ordering works and services. So the topic of our conference is new challenges to the integration. The issue of free movement of goods and services is something that the Eurasian Economic Community, the EUROSEC, has had experience with. Initially, the freedom of movement of goods was declared. However, the workforce freedom of movement is the experience of a more profound integration within the Eurasian Economic Union, EAEU. But I believe that all the prerequisites are there in the treaty and specifically in the preamble there too. And it's not just the initiative for the employers, but also to law enforcement bodies. The guarantees put forward by the treaty on the EAEU with respect to one of the key freedoms cannot be discarded neither by national legislators nor by law enforcement agencies. Thank you very much. I would welcome any questions should there be any.
Thank you very much, Ekaterina, for the comprehensive presentation. Well, the Court of EAEU has considered the case, the so-called case about the sportsman what consultative opinion expressed was related to Article 97 of the treaty, and the court endorsed the principle that Article 97 is of direct application and should be therefore applied in all member states, even though there is a contradiction between Article 97 and the provisions of the national labor relations, so that Article 97 should directly be applied. In addition, in consultative opinion of the court, it was mentioned that there should be relieved, any limitations should be relieved related to labor activity and employment of the citizens of the member states. So all issues and questions that you've been elucidating, including the Court of EAEU, has introduced its contribution in resolving these issues. Once again, thank you very much indeed for your involvement. Respected participants of the conference, so all people that were going to take the floor have taken the floor. In the course of discussion of the presentations, there are a number of questions received. Actually, a lot of questions have been received. Many of those relate to advice and counseling on this or that issue, mechanism of application to the court. However, the questions related to presentations, say, for example, Mr. Alexander Yerofeev is analytical magazine Tender, Republic of Belarus. He is asking the presenter from the Eurasian Economic Commission. The question is follows. Doesn't it seem to you that the volume of legislation became unbearable for the economic entities? I mean, the regulatory framework and agreements. Maybe the most important objective should be aimed at simplification of the legislation. It's one question. And the second question, again, aimed at Eurasian Economic Commission, Alina Arnautova, so the student of the High School of Economics. So, treaty on the Eurasian Economic Union envisages the rapprochement between the states, since all member states would commonly and universally apply provisions of the legislation related to economic activity until 2025. Rapprochement of the legislation should be done based on the principle of unification and harmonization. What is your opinion in this respect? So the question is whether unification or harmonization should be applied, and whether it is possible, say, at any moment of time or simultaneously to switch to unification of legislation. Maybe someone from the Eurasian Economic Commission who is online, would you be brave to take this question and answer? Well, they say that doesn't seem to be people on. Oskar Bolatovich is... Do we have Oskar online? No. Well, unfortunately, since we don't have anyone, so probably the working day is over. However, there's a question to Mark of the same student of the BA student. Respected Mark, what is the specific issue, in inverted commas, of building in of trans-regional association EAEU into the system of international law? Mark, once again, if you are online, please be with us, stay with us and answer. Well, we can understand celebration of the birthday. Would anyone who have been taking the floor would like to say something in conclusion? So make sure that you put your microphones on. You will be online, and then you would add something or take part in discussion, exchange opinions. So if anyone would like to take the floor, please make sure that you express. If not, then we would call it a day. So thank you very much indeed for accepting the invitation, and thank you very much indeed for active participation in discussion. All the speakers conscientiously have been preparing their presentations, have touched important issues of integration or association, legal support, interaction between the courts, both on national level, with the Court of the Integration Association, and then questions arising in this kind of interaction. So therefore, I believe that the day was productive, and it was due to your active involvement, dear presenters and dear speakers. In this situation, we would like to discuss a break, announce a break until Minsk time, 11 a.m. We expect to resume our activity tomorrow at 11 a.m. Thank you very much indeed. All the best.